State of Wisconsin versus Darrell Brooks.
Good morning, Judge. Sue Opper, Leslie Basie, and Zach Witchow appearing for the State of Wisconsin.
I'm here as a third-party intervener in that matter. I do not dispute any of the facts in the charging instruments.
Anything the parties wish to take up prior to the jury coming out?
Again, I do not consent or agree to being called that name.
Every inmate communication form has the name Darrell Brooks Jr. I'm going to still keep referring to you as Mr. Brooks. I know you as Mr. Brooks. So I just want you to know that's not a disrespectful thing. It's out of respect for these proceedings.
No disrespect taken whatsoever, Your Honor. And for the record, I still would not consent to that name or agree to that name.
All right, do you have any documents to file today, sir?
Yes, I do.
All right, if you could hand that to the bailiff.
Just very brief things I would like to put on the record.
I'll have the bailiff first show it to the state, as that is proper, and then it'll come to me.
Deputy.
All right, the record to reflect I have received a document that has a caption for this case, 2 short paragraphs, and then a signature at the bottom with the name Darrell Edward Brooks Jr., authorized representative of Darrell E. Brooks, all rights reserved. I'm not sure what you're asking me to do with it as well. I don't see a clear request for relief as well. Do you want a copy of that for your records, sir?
Yes, I do. The time-stamped original copy, if I may. And also, to my knowledge, the filing is proper unless Your Honor can provide verified law of your own that is not a proper document. I think it's very clear what the document is referring to. The language is all together. It's a very, very clear document in its entirety, presented in the same fashion that all my motions in this court have been presented, and you never cited the same thing with the other filings. So that's leading me to believe that it's just that document that's not being accepted when I have the other timestamp filings for the same documents that I filed. Every other document is filed in the same manner, every last one of them, and no exception with that one, Your Honor.
I'm not sure what it is you're asking me. It's not going to prevent this court from proceeding forward and continuing on with the trial.
For the record, Your Honor, can you state why? Because it's clear what this is referring to. It's referring to why there's no bond mentioned or stated in the court document, the docket sheet. There's no bond in any of these writings. Not one time does it mention it.
I understand what it's referring to, sir.
Also,
there's no legal basis for your argument.
Also, for the record, this docket is not a certified copy, which is what I requested.
You need to make a specific request to the custodian of the court record.
That's what I did, Your Honor. The ICF should be on record that I specifically requested. I specifically requested a certified copy.
Sir, I am not in charge of that, so I'm not going to address that any further. I am not the custodian of the record. The custodian of the record needs to reply to that. That is our clerk of court. If you believe she did not do that, then you have recourse available to you, but it's not through this case. Let's have the jury brought out.
I was not provided with exactly what I asked for. If I'm told by the court to submit an ICF for any requesting, and I requested specifically a certified copy of the docket sheet and was not provided with what I specifically asked for, then how?
Sir, I can't address that any further. But I'm not going to do it through this court proceeding.
I would like that stated for the record that I did not receive what I specifically asked for, and I'm sure that the ICF is on record. I can get...
Mr. Brooks, for the record, we're on the record. And so
Okay.
everything that we're saying is on the record. So it's noted. Bring the jury out, please.
Also, I have one more thing I wanted to state for the record.
Go ahead.
Which was also submitted via inmate communication form. So that should be on the record and it should be filed. I know it should have been received by now. It was addressed to Miss Monica Paz, and it was asking for the complaint that was filed. It was 3 different complaints. They're found in the docket sheet. One from 11/23 of 2021, one from 11/29 of 2021, which would be the amended complaint, and then one from January 12 of 2022, which would be the second amended complaint. I specifically asked for copies of those to be provided as they were not in any discovery.
I am not going to answer for Clerk of Court Paz. She is the custodian of the record. All right. So you're going to have to communicate directly with her. If you're looking for just copies, I'm happy to print those off for you. I've already provided some of those things to you. I hear you saying you want certified copies. That would not be provided by me. Are you looking for certified copies or just copies?
Certified copies.
All right, then that will have to be addressed by Clerk of Court Paz.
So how would I do that? Because I
can't, sir. I've already told you need to make the request to her. That's how I have to leave it, sir. I'm not the custodian of the record, so.
I addressed it that way, Your Honor. I addressed it the way I was told to address it from
My
the court.
understanding is it went to her. So with that, let's have the jury brought out. Your position's noted.
All right.
Your Honor, can we address the subject matter jurisdiction before the jury comes out? The jury comes out?
We've already done it.
And is that a judicial determination that you're making not to address the subject matter jurisdiction, which has yet to be proven at this point? It has not been
Mr.
verified?
Brooks, please, the jury's coming out. I know what you're doing, but I've already addressed that.
So is that a judicial determination that you're making?
My decision on the record stands, sir.
And I would like the record to reflect that you have not shown verified proof of subject matter jurisdiction whatsoever, and that by refusing to answer, that is a tacit agreement by you, Your Honor, which you understand what that means. I know you do.
Mr. Brooks, I have not entered into any such agreement, and because the jury is out and you are claiming that there's some issue, I'm going to take this up later, but I will entertain a request from the state for a curative jury
You
instruction.
have a pretty standard formation that you would keep to do each of your routines during the parade.
Yes.
Did you have uniforms?
Yes, we did.
Can you describe them for the jury?
Objection, relevant.
Overruled. You may answer.
Grounds for it.
Did you have, I'm assuming if you were dancing to music, that you had something that played the music.
Yes, we have a music vehicle
Where would that music vehicle be in relationship to the group who was performing?
right behind the group.
Oh, hold on. There's been an objection. It's noted. It's overruled. Her answer may stand. Just in the future, if there is an objection, wait until I've ruled on it and then answer if I say overruled. Okay?
Okay.
Thank you.
Overruled.
Relevant.
Grounds for the relevancy.
Keep going.
Okay, and you said there's also another support person who carried ice chips.
Yes.
Do you know who that was last year?
Objection, relevancy.
Overruled. You may answer.
Grounds for the overrule.
I should.
You can answer.
Okay. Yes,
Grounds for the
Bill.
overrule.
Why don't you describe for the jury exactly what's in front of you?
Objection.
Overruled.
Grounds.
You may answer.
Okay, we have 9 people that were in the parade.
We have the names. It says banner, and then on the left-hand side, as I'm looking at that, it's Ginny Sorensen and Allie. Is that correct?
Yes.
And I'm going to actually ask that this be published also for the jury and admitted into evidence.
Objection. We have yet to see what's being talked about being shown.
Does Mr.
It's up now.
Brooks have a copy?
Objection. I do not consent to being called that name, nor do I agree to being called that name.
Based upon the testimony of this witness, Exhibit 54 is received permission to publish as granted.
Objection.
Noted. Overruled.
On what grounds?
Mr. Brooks, I'm not going to be specifically addressing, so please respect that.
I respectfully request a legal reconsideration of your ruling.
Mr. Brooks, now is not the time for that. The objection has been overruled. I expect that you will honor that, and we will continue without interruption. Go ahead.
I do honor it, Your Honor. For the record, I respectfully reject that ruling and take exception to that ruling.
And the 9 people who are listed in the boxes following or behind the banner, does that accurately reflect the lineup that you had on November 21st of last year?
Yes.
Okay.
Overruled. Her answer may stand.
I would ask the court to admit this Exhibit 53 into evidence and publish it for the jury.
Objection.
Overruled. Exhibit 53 is received. Permission to publish is granted.
Grounds for the overrule.
Ma'am, I'm going to play it straight through and then we'll go back and go through it and pause it occasionally for you to identify everyone, okay?
Grounds for the overrule, Your Honor.
The state may continue.
All right, is that a legal determination that you don't have to give me the grounds for the overrule, as I have objected on the
Mr.
record?
Brooks, stop interrupting. I've made my ruling. Let's keep going. Go ahead.
Thank you.
I ask for a written judicial finding of facts and conclusion of law. Or is that a tactic agreement, Your Honor?
And will you be able to identify each of the people if I go through the exhibit and kind of pause it occasionally for you to tell us who they are and a little bit about them?
Objection, hearsay.
Thank you.
Overruled.
Grounds for the overrule.
Maybe I misunderstood. When you say the left side of the street was where Lee Owen was, or the left side of the picture as you're looking at your screen?
Lee was on the left, right behind Ginny.
Miss B,
Oops.
it's okay. There's been an objection.
Okay, so
Okay.
right behind Ginny was Lee Owen.
Yes.
Is her full name Leanna Owen?
Lee was
Overruled.
very Lola
Okay, can you circle Lola?
Hospital. She is the wife of Bill that was hit.
Okay.
Question.
Noted. It's overruled. Her answer may stand. Next question.
Grounds.
Can you identify the person who is behind Lola and Kathy in the video?
Yeah, she would be in the middle. That is
Hold on. There's been an objection. It's overruled.
Grounds.
She may answer.
Grounds.
that's Tamara, and 2 Kathys too. but-
Okay.
And this is Kathy
Is that
Zar-
Zartek?
Zartek or
Leading the
something
witness.
like that.
Hold on. There has been an objection.
Okay.
And I would just note for the record, Exhibit 54 is in front of this witness.
That was not the question. It was leading.
For purposes of identification, though, I'm going to instruct her to turn the Exhibit 54 over to make sure that her testimony today is from her recollection and not from reading from a form. So if you could turn that over, please.
Directing your attention to Miss Durand, can you
Yes.
tell us a little bit about her?
She was new, and this again was her first parade. She was so excited about being a granny because she had worked for months and months to learn all the routines. She was so excited. She just couldn't wait. She was looking forward to doing all the parades. That was the first and last parade she ever did.
Do you see a figure entering into the screenshot? Do you know who that is?
This would be Bill.
Thank you. And that's Bill Wilhelm.
Pardon?
Do you know the last name?
It's been rephrased.
Hospital.
And do you recall him wearing a hat that day, as shown in the picture?
Objection, leading the witness.
Overruled.
Grounds.
Did you at any time turn around and see something unusual?
Yeah, as we were going and I was dancing, when I would turn, I seen a streak of red coming on my right side.
How fast was that streak of red going?
It was going pretty fast.
Hold on. The objection's noted. It's overruled. Her answer may stand.
Grounds for the overrule.
I didn't see them get hit because it all happened so quick that I was still dancing.
Did it stop after it struck, I think you said it struck the people in the front. Who were the people that you just testified to that died?
Objection, leading the witness.
Overruled.
Grounds.
I'm going to bring up Exhibit 54 again.
Go ahead.
And I'd ask that be published to the jury. It's previously been admitted into evidence.
Go ahead.
Objection. What's the relevancy of the video?
It's Exhibit 54. The court's already admitted it. It is shown to the jury. Go ahead.
Ma'am, can you, when the car went through, can you approximate where Bill was? on this chart. You can put an X where you think he was.
Bill was about
Objection.
here.
I thought the sheet wasn't being shown. You specifically made a ruling for the sheet to be turned over.
I thought I was in a war. There were just so many, and I just went into shock, and I just grabbed my jacket like this and went to each body to see who it was and if I could help.
You said that you grabbed your jacket. You held both sides of your jacket up to your neck area. Would that be a fair statement?
Yes,
Objection.
I think I
Relevancy.
needed.
Hold on. The objection's noted. It's overruled. Her answer and the description provided for the record by Attorney Basie, I would note, was accurate. You may continue.
Grounds for the overrule.
The people that you saw laying in the road, were all of those people from your group?
Objection.
Yes.
Hearsay.
Overruled, not hearsay.
The two of them I couldn't find. The rest of the people were accounted for, but I didn't know where they were, so when they were hit, they went flying on the sidewalk. Bill was on the right side. He kind of was thrown on the sidewalk.
Did you go by him at all, or?
Yes,
Objection.
I talked to him.
Hold on. There's been an objection.
Oh, I didn't hear him.
It's overruled, and her answer that she gave me.
I didn't even state the objection, but
Ma'am, can you, is this look to be Main Street, the parade route from November 21st of 2021?
objection. Leading the witness.
Do you see, does it appear to be a map or something else?
Objection.
Pardon?
Leading the witness.
Do you see a purple line on that map?
Yeah, with all the purple stars on.
I don't know if they're purple stars, but I see some yellow stars, some orange stars.
Yes.
Objection.
Yes.
Leading the witness.
This has previously been marked and admitted into evidence. I think I can direct her attention to these items.
Agreed.
I think
Your objection is noted. It's overruled. This exhibit has previously been received.
I think the stars the color are pretty obvious what they are.
There's various color stars, and
It's
again,
only
the
two
exhibit's
color
been
stars.
received. The jury can determine for itself later on.
7 names in that box. Are those all part of the Dancing Grannies?
Objection. Leading the witness.
Overruled. She may answer.
Grounds.
And you see that there's a black line that directs it to a yellow star. Do you see that?
Objection. Leading the witness.
Yes.
Overruled.
I'd now like to show Exhibit 55. Does that accurately depict what occurred to your group on November 21st, 2021?
Yes, it does.
I'm going to ask that it be admitted into evidence and published to the jury.
Objection.
Overruled.
Grounds.
And did you see headlights coming through your group?
No, because it came from the back.
I'm sorry, in the video, did you see headlights
Oh,
coming through?
yes.
Objection. Leading the witness.
Yes.
I want to show it one more time for the jury so that they can now focus on the headlights on the vehicle.
Objection. Relevancy.
Your objection's noted. It's overruled.
Grounds.
Permission to publish once again
Grounds.
is granted.
And Your Honor, the state is going to play it at 50%.
Grounds. Objection. Grounds.
Noted. Overruled.
Grounds. I request legal reconsideration of your ruling.
Denied.
Grounds of the denial. For the record, may I request a legal or factual basis for your ruling? Is that a legal determination, Your Honor? Are you making a judicial determination?
Did you see the body come forward and fly in front of the truck?
No, me being in
I'm
back.
sorry, in the video, did you see the body
Objection.
flying in front of the
Legal
truck?
witness.
It's not
No.
leading.
And do you know who that was?
Yes.
Who was that?
When they had it on TV, that was
No,
the man, right?
I'm sorry.
Hold on one second. That last answer, I'm going to, because it was non-responsive, but I'm going to strike it, instruct the jury to disregard it.
If we can go to Exhibit 55 again, to approximately the 10-second mark.
Are you withdrawing that last question then?
Yes, I am.
Okay, thank you.
Can that be struck? The question?
It's been withdrawn.
Can it be struck from the record?
It's been withdrawn.
May it be struck from the record?
There does not need to be struck. So the request is denied. It's been withdrawn.
May I ask for a legal and factual
Remarks
basis
of
for
the
your ruling?
attorneys and questions of the attorneys are not evidence.
Car hit them, it was on my side, and I didn't see them flying or anything. I just.
But you saw the car come through, and you previously testified that you saw the car strike them. You didn't see where they went. Is that fair?
Objection, leading the witness.
Overruled. That answer may stand.
I'm going to ask that this be admitted into evidence and published to the jury.
Objection. Where's the relevancy?
The objection's noted, it's overruled, and Exhibit 152 is received. Permission to publish is granted.
Grounds for your ruling, Your Honor.
Relevance.
Ma'am, who did that red vehicle strike in that exhibit 152?
Objection. Leading the witness. Saw the video.
Tomorrow,
Hold on, there's been an objection, everyone. The objection is noted, it's overruled. Now you may answer the question.
Grounds for the overrule, Your Honor.
It's overruled, you may answer.
Grounds for the overrule, Your Honor.
Go ahead, you may
Tomorrow,
answer.
Duran.
And that was the car that you saw travel in front of you?
Yes.
Objection, leading the witness.
Overruled.
Grounds for the overrule, Your Honor.
It's overruled. Next
Grounds.
question.
Then direct the witness's attention to exhibit 153, which will show just in front of your screen, okay?
Grounds.
Exhibit 152 was received already. No need to address the request for grounds by Mr. Brook due to that. And then the exhibit is up in front of the court, the witness, and the parties, but not published.
Objection. I do not consent to or agree to being called that name, Your Honor, for the record.
Go ahead, Attorney Basie.
Thank you. This clip
Would that be
is...
noted for the record, Your Honor?
Go ahead, Attorney Basie.
Thank you.
May that be noted for the
Mr.
record, Your
Brooks,
Honor?
stop interrupting.
I just want to make
Mr.
sure
Brooks, stop.
I just want to make sure it's on the record.
I'd ask that exhibit 153 be admitted into evidence and be published for the jury.
Objection. Relevancy.
I see we may have a future granny in front of us here with the green hair.
Sure looks like it.
Objection. Relevancy.
I would just ask, did you see after Bill Hospital was struck, did you see some feet coming through the screen on the bottom at the very end of that clip?
Objection. Relevancy.
I seen him in the.
Overruled.
Nothing further, thank you.
Ma'am, I'm going to give Mr. Brooks an opportunity to ask you questions as well. Please answer those for him. Go ahead, your cross.
During your testimony, you kept referring to a he. Who were you referring to when you said he?
I can't understand him.
Can you please state your question a little bit louder? She was not able
Yeah.
to hear.
I apologize. I'm sorry. During your testimony, you kept referring to a he. Like a lot of times you would say he. Who were you referring to by the he? Who did you mean by the he?
He,
Yes.
when it was showing Bill,
No, not
Bill
the,
would be the he.
Before today, have you seen any of those videos before today? You stated that you saw a red vehicle strike the grannies. Do you remember if that was, or let me back up. Do you remember what type of vehicle you saw?
It was like an SUV. It wasn't just a car. It was, the flat back.
Would you describe it as a car?
It was a vehicle.
How close did it come to you, if you recall? Were you able to see into the vehicle in any way?
No, because it came behind me.
So you didn't get a look at the driver at all?
No, I don't have eyes in the back of my head.
Do you recall what happened when people were struck by the vehicle? Earlier you testified to people being thrown to the side of the street. Would it be fair to say that, and I'm going off your last answer to the last question, would it be fair to say that you didn't see that with your own eyes?
No, that's where they were found.
But you didn't see it with your own eyes?
No, I couldn't.
You also stated that a few of the people that were struck died instantly. Would that be fair to say? You stated that a few people that were struck died instantly. How would you know for sure that they died instantly if you didn't see them struck?
Two of them on the sidewalk, one on the left, one on the right. They were already dead.
So were you told by the police that they were dead?
They were trying to get the heart started with the heart machines. Nothing was working.
And you know that for sure. So was it fair to say at that time that you had no medical diagnosis at that point in time?
Nobody gives nobody diagnosis.
So it would be fair to say at that time you had no knowledge of the injuries sustained. You stated that, I believe it was a Kathy. Did you know a Kathy that was part of your group? You stated, I don't remember which one, but you stated that one of the Kathys had a sister or something. Do you recall the sister's name? Are you sure it was a sister or maybe just a relative?
I figured it was a sister.
So it would be fair to say you didn't know for sure who it was. You stated that there was a music vanners, and you also stated that you couldn't hear what was going on behind you because the music van. Would that be fair to say? So would it be fair to say that if a vehicle was honking a horn, you wouldn't have heard it if it was behind you?
I don't know. No, there was no horns.
But you don't know for sure because you stated that the music was playing pretty loudly. Would that be fair to say?
Whether I would hear a horn or not, I don't know.
Were you able to see a license plate number of the vehicle?
Didn't have time to read a license plate.
And you stated that there's also a member of your group named Lola. And she, to your knowledge, to your recollection, Lola was not injured. You spoke with knowledge of a lot of the injuries. Would that be fair to say? Have you yourself ever had any medical training of any kind? Have you yourself ever been in the medical field?
No.
Did you see anyone behind you struck? And you yourself weren't injured, right?
No.
You stated that you went inside of a building at some point, or
Yes.
one of the businesses, and you stated that you couldn't stay in there because you wanted to see how bad everything was outside. Would that be fair to say? Do you recall about how long you stayed in the tavern, I think you said it was, before you went back out? So when were you informed by, I guess I would say, medical personnel of the injuries to your group?
When I seen them working on them, they had the heart machine on Ginny, and blood was pouring out of her mouth, and I knew she was gone.
At any time during the incident, did medical personnel come to you and
No.
tell you injuries? At one point in your earlier testimony, you pointed to the defendant table and said, "That's him from the news." Any reason why you would say that?
From the news. I didn't say that.
You testified that you pointed to the defendant's table and said, "That's him from the news," and you were cut off right in mid-sentence.
I wasn't saying that. And when they had it on TV, that was the man
So
right.
have you ever seen any news coverage of the incident? At any time, do you recall seeing any news reports related to the incident? At any time?
It was on the news, yes.
So it would be fair to say that you watched reports of the incident. Fair to say you learned additional information that you didn't have when you were at the incident. So would it be fair to say that before you received information from the families, you weren't sure of the exact injuries to the grannies in your group?
Some of them I knew right away.
Did you know just from observation, or were you told?
I was pretty much told.
And from the videos that you saw here today, which you already stated it was your first time seeing any of those videos.
Yes.
Did you see anything in those videos today that you didn't see at the time of the incident?
Yeah, the people being hit and flying.
But you didn't actually see.
I couldn't. The car was in my way.
And do you recall who else was not injured from your group? Do you recall the names of who was not injured? Both Kathys, to your knowledge, were not injured?
No, they weren't.
Do you recall about what time you left the parade after the incident?
What do you mean after the incident?
Do you recall what time you left the parade?
I had to find a way home because the music vehicle had to stay there because it was a crime scene. So Kathy Z's family took her home, so they gave me a ride right away too.
And you don't recall about what time that was?
No.
That would be fair with everything else going on. At any time in the days following the incident, did you see any reports of a suspect at any time? And what are you referencing when you say found?
The police found him.
I don't recall if this question was asked, so I'm going to ask it. Were you there with any of your family members, immediate family or anything?
It was just my husband.
Was he injured in any way?
No.
Do you recall giving any police statement, or were you interviewed by any law enforcement? Do you recall if it was the same night of the incident or in the days following? Did you ever file any claims related to the incident?
Not of the incident, no, because I was there when they were talking to the gals that weren't hurt. They were like interviewing us.
The four of you, correct? The four that went, the
all
two
of us.
Cassie.
Yeah, the ones that were left.
Do you know if they filed any claims related to the incident?
If what?
Do you know if they filed any claims related to the incident?
Objections?
Grounds?
Calls for speculation.
Grounds?
The way that he asked it is overruled, so you may answer if you know.
Okay, no, because we were all together and came to every interview that they needed from us.
Do you recall seeing or reading any complaints related to the incident?
Objection.
Grounds?
Sustained.
Should I rephrase the question? Or at any time during any interviews with law enforcement, were you shown a complaint related to the incident?
Objection, Ben.
Grounds?
Sustained as to the form of the question.
Were you informed that it may be a possibility that you might be called to testify in this matter?
I had no idea of testimony until
Would you say much later, as you say, would that refer to weeks, months? Do you recall seeking to testify, wanting to testify? So it would be fair to say that you were asked. Do you recall by whom? When you say the DA's, do you mean the district attorney's office? Did they ever identify to you as being the plaintiff in this matter?
Objection.
Grounds?
Sustained. Next question.
Grounds for the substandard, Your Honor. Do you recall ever being told that there was a plaintiff in this matter? I think probably a little explanation is needed. Are you aware what a plaintiff is?
Objection, relevance.
Grounds.
Sustained.
Grounds for the substandard, Your Honor.
Next question, Mr. Brooks.
Grounds for the sustain, Your Honor.
Ask your next question, please.
I am. I just want to know the grounds, just for the record, the grounds for the sustain.
Ask your next question.
Your Honor, the grounds should be put on the record.
Ask your next question. I'll address this all at the next break outside the presence of the jury. Ask your next question.
Your Honor, with all respect, I think the jury
Mr. Brooks, under
deserves.
90611, ask your next question, or I will determine that the cross-examination is now closed.
I'm
Keep
gonna
going.
ask, I'm gonna keep going. I just think the jury deserves to hear.
Mr.
all
Brooks,
the
I'm
testimony.
instructing you to stop making those statements. The jury will disregard. This is the cross-examination. It's not your opportunity to make legal arguments or to testify. You'll have an opportunity if you so choose to do that later.
With all respect,
Next
that is not
question.
question. The jury just deserves to know.
All right, under 90611, the cross-examination
I still
will
have
be
a question,
determined.
Your Honor.
Sir, you didn't follow my very clear instructions. Does the state have any follow-up?
No, Your Honor.
All right, thank you, ma'am. You may step
Objection
down.
to that, Your Honor.
Your
I was
objection's
not-
noted. Ma'am, you
I
may
was
step
not-
down, and after she steps down, I will be excusing the jury for a few moments. Please rise for the witness and for the jury as they leave the courtroom. Mr. Brooks, please wait. To specifically address the repeated request by Mr. Brooks for the court to state the grounds, sir, I am not legally required to do that. Many of the hearsay objections are baseless. Your objection to hearsay is it's not hearsay. So you need to be aware, sir, that when you ask for the grounds, you're asking me to state a legal conclusion in front of the jury. So
Is that a judicial determination that I violated 90611 when...
I'm advising you, sir.
Your Honor, I'm not interrupting you. I'm letting you make a clear record. And
Mr. Brooks, you have actually interrupted me.
I just let you go through the whole citing of 90611 without saying anything.
I'm not asking for the parties to make an argument under 90611.
So
I'm
why
advising
reason?
you. Stop interrupting me, please. I'm advising you, sir.
I'm well aware of what I'm citing, Your Honor. Well aware.
All right, so-
And I'm just seeking for the record to be clear. With all due respect, Your Honor, that's judicial misconduct because you're not allowing the jury who deserves to hear certain aspects of testimony. Like I stated yesterday, under the Sixth Amendment, I have the right to face my accuser, which means that I can question about clearly the plaintiff being the accuser. How come I can't question about if a witness may know or have had any prior interactions or any conversations or anything of the sort with the plaintiff who has yet to show their face? Also, the reason why I was objecting the way I was is because I was trying to get to the question of the witness saying that about the 4 ladies in her group that were not injured. There's relevancy because with her stating on the record, clearly for the record and for Your Honor and for the court and for the jury that these ladies were not injured in any way, but yet there's still charges associated with these ladies who were not injured. That should be dismissed. May I request a legal reconsideration of your ruling, Your Honor?
You interrupted me. I'm not done with what I was trying to say.
It was no way for me to know that because you paused. I'm sorry. I apologize.
Just because I paused doesn't mean I'm done.
But you paused for quite a while, so I wasn't sure.
In any event, sir, we're going to keep going. Or does the state have
I'm
their
not
next
trying to-
witness available? Please do not interrupt. I'm asking a
And that's
standard
why
question.
that's why I was
Mr.
just quiet.
Brooks, you're interrupting. Stop.
For the record, Your Honor, we haven't addressed subject matter, jurisdiction.
We are off the record.
I don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different. Bring the jury up.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown any verified proof that this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this
please.
the military
All right, can
power?
you please take the jury out? Thank you.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait till the jury's out, please. I ask that you show that respect.
I will.
Thank you. Did Mr. Brooks just make your statements? What do you want to advise the court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
I don't understand what you're asking me, sir.
I'm asking, is
And on what
this...
legal basis are you making that request?
I'm asking, for the record, is this a common law court or an admiralty court? What are we in here? I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me, that I wanted everything to be certified. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office. I've brought up my Sixth Amendment constitutional right that has been pretty much discarded, that I have the right to face my accuser. An entity cannot make a claim. There's so many biases, clear biases in questions that are not being asked based on judicial determinations made by Your Honor. I think at minimum I deserve for the subject matter jurisdiction to be verified and proven. As we sit here today, I'm still not even understanding the nature and cause of the charges. I'm basically sitting here confused because I don't understand why these proceedings are allowed to continue when there's so many things that have not been provided. I move for this case to be dismissed for failure to appear by the plaintiff. Everything that I'm saying, it has merit and it has validity. There's so many things left to still be proven. The prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. There's so many things, and Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. It's to the point where, Your Honor, you should recuse yourself from the presiding. If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter. How is this case allowed to continue without these documents and filings being verified? I'm just asking for Your Honor to be fair, which is another right that I have, the right to a fair trial and the right to an impartial jury. Where's the injured party? The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question. Where is the plaintiff? When it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. I have the right to challenge the jurisdiction of this court. In fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year. We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. The discovery, in its entirety, was brung to my housing unit on the 29th of September. How can I go through all of that and be prepared in 3 days? There is no possible way, humanly possible, that I can be ready for a trial of this magnitude in 3 days. Where's the injured party? And because of that, Your Honor, the motion to dismiss should be granted. There's no injured party in this matter. I have the right to say what I want and to be heard under the First Amendment. But because I don't understand, I raise these issues. I've repeatedly asked the court for a motion for a finding of fact. I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated. We're way past the speedy trial date. At minimum, the venue should have been changed based on the fact of the magnitude of the matter. There's no way that this trial should be taking place in Waukesha County. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. Again, I go back to the Sixth Amendment again. When I asked for the motion for the evidence motion that I raised, clearly there's been repeated violations of my Sixth Amendment. There's still no basis for the motions being shot down. Why was I not granted the motion for finding a fact? Why did it take so long for me to be brought my entire motion for discovery? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted? Which brings me to the motion to subpoena witnesses. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment I have the right to face my accuser, which is the plaintiff of the case? How could the subpoena not be filed, and how could the plaintiff not be called to the witness stand? That begs the question of, does the plaintiff even exist? So the question still stands. How can an entity bring a claim if it's not a living human being? So where's the claim? Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify? They don't exist. Therefore, the claim doesn't exist. For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed. We're still talking about jurisdiction. I also have the right to call any witnesses to assist my defense, which is the main reason why I subpoenaed the plaintiff in this matter. Are you or are you not a public servant? I still have filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that is not my name, nor do I consent or agree to being called that name. We go through this every time I come here. You bring up Illinois versus Allen when we had the issue of me being removed from the courtroom. Illinois versus Allen states that there are 3 options when a defendant is being disruptive in court. You identified a 4th one, which is not cited anywhere in that case. How did you come up with a 4th option that's not written? You take it upon yourself to add this 4th option to justify denying me my constitutional right by being present. Nowhere does it say you can create a 4th option. It's treason not to uphold your oath of office. Treason. You repeatedly make judicial determinations that clearly prejudice my defense. The constant push not to have an informed jury, not giving legal valid grounds on objections, not noting objections for the record to make sure that the record is clear. I'm sure somewhere in the jury instruction you informed them that the state of Wisconsin was bringing the claim, but then you make the judicial determination that I'm not allowed to ask questions about the plaintiff. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per jail administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day, not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be at least in some form general population with an upcoming trial. Reference was made to being able to use LexisNexis or whatever it's called. We call it the law library. That may be the easier way to describe it. I'm only allowed to access the law library at certain times during the day. That prejudiced my defense. In a proceeding of this magnitude, there should not be even a time where I don't have access to the materials that I need. Which brings me back again to the change of venue again. Even right now with trial going on, there's still political ads being shown every day that reference this incident. There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up. The sheer insensitivity of some of the things that are said. That I have children too. To constantly say and report this incident as attack. Terrorism. It's unfair and it's insensitive. But it's very insensitive and unfair to not recognize that there's many other victims that never is talked about. It's not only hurtful, but it's insensitive and it's not true. There's so much bias that's going on that, and even with all this, for the record, we still have no proof of jurisdiction. We still have no plaintiff. We still have no claim. There's no proof if you hold the full judicial power of the state, or is it the military?
Mr. Brooks, I've given you about 50 minutes to make your various arguments. You've now repeated yourself a number of times. So I'm going to turn to the state to see if they have any response.
Sovereign citizen theories are frivolous and wholly without merit. Mr. Brooks, knowingly...
I to being called that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial. He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today: the resources of the state, the knowledge of the law, his ignorance of the law. And his words to this court, and I quote to the best of my ability, It don't make me flinch one bit. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator if he accused this court of treason, but I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely. I want to address this claim that he only had 3 days to prepare for trial. It's absolutely a false statement. The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. We know that because he's tried to confront witnesses with the notes from the public defender. He is not going into this blind or with one arm tied behind his back. They did all the homework, and he's simply sitting here reading their notes, reading their cross-examination questions, and asking the questions, and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement. He's never asked for a speedy trial. He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to trial, and on the other hand, we're rushing him to this case and he hasn't had adequate time to prepare. He misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety, so that other inmates do not inflict physical harm upon him. Once a defendant has asserted his right to refuse counsel and conduct his own defense, he has no constitutional right to access those resources. And again, you warned him, Judge. You fairly warned him. And he basically acted as if you were insulting him and said it didn't make him flinch one bit. He has an agenda here. It's to stall, delay, disrupt, intimidate, and it's not going to work.
Objection to that. Your Honor, that's a load of crap.
Mr. Brooks, that's my opportunity now. I gave you about 50 minutes.
I just want to object to the disrespectful comments that was just made. I'm not trying to hold you up from what you're going to say, but that's a load of crap.
Mr. Brooks,
for her to sit there.
Mr. Brooks.
For her to sit there.
Objection is noted.
For her to sit there, Your Honor.
It's my turn. Let me go through this. I graciously gave you 50 minutes to raise all these various points that you want to bring up. I then gave the state an opportunity to respond. As I indicated, the defendant spoke for about 50 minutes, raising a litany of complaints and issues and theories regarding his view of how this case has proceeded. Many of these issues, if not the vast majority or even all of them, have already been addressed by this court in one way or the other. It is true this court denied the change of venue motion. To say that this jury is biased would be a complete miscarriage of justice. As I listened to the litany of issues and arguments and complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law and fact. There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining, I should say, or overruling objections, for an example. There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no different why the case law is very clear. You can't yell fire in a crowded theater. No one has a First Amendment right to do that. In a criminal case, the parties have an obligation to follow not only the Constitution and the statutes that are applicable, but to follow criminal procedure, the rules of evidence, the issues you raise, for example, regarding subject matter jurisdiction are baseless, they're frivolous, and they're not anything this court needs to address further. The fact that you now are asking questions about whether this is admiralty court or a military court or a court of competent jurisdiction is frivolous. The only argument or relief that I could discern through the course of those 50 minutes was Mr. Brooks's request that this case be dismissed for lack of subject matter jurisdiction. And as I have just indicated, this court has jurisdiction. It's not been raised. Let me rephrase that. The issue has not even been raised properly. The vast majority of the points that you raise, sir, are issues that you can raise on appeal. So the fact that you complain about what I do, it's noted. The record is going to be very clear. I have a court reporter who's taking down the record of everything that is said and done in this courtroom when we are on the record. And so I don't have to all the time say it's noted for the record because we're on the record. You raise issues concerning, I guess, plea bargaining. I have never been made aware that you would want to change your plea in this case, and that you're not aware of the state wanting to do that. That is the first time any such issue has been raised, and I see it as a distraction. While it's true you have a right to seek substitution of judge, it is not unfettered. There was a time limit for that. In fact, it was exercised because a prior judge was assigned to this case, and your attorneys on your behalf exercise that right of substitution. This trial will keep going. I still expect the basic rules of civility and decorum to be followed. As far as the other issues you raise concerning your right to assistance of counsel, I believe I honored your request to represent yourself. You made a very deliberate choice after being fully advised and aware of all the requirements that I needed to go through under the case law. I let you put on the record all of those points in order to give you that opportunity to make a full record of the issues that you have believed that you are entitled to raise. But those sovereign arguments regarding written findings of fact, bill of particulars, regarding contracts that you enter into, regarding admiralty court, etc., they're baseless, sir. And this court need not address them further. Now, with that, I know it's 11:30, but I would like to get one more witness on before at least we break for lunch. The jury, of course, has been out for quite some time.
For the record, Your Honor, we didn't bring up the Higgins-Levine 415 U.S. 533 decision. That was not addressed, and the issues are still not addressed. There's still been no proof to anything that you said, anything that the prosecution has said. It still hasn't been.
As noted, and we will continue. Bring the jury out, please.
There still hasn't been
Mr. Brooks,
any proof.
I've addressed them
There
to the
still
extent
hasn't
that I
been any
will.
proof. There still hasn't been any proof. I never once. The comment about me not flinching was when you said that there's 66 years of experience at that table. That's the comment I said that doesn't make me flinch. That was mischaracterized. That should be for the record. There's still been no proof.
Mr. Brooks, please stop. I'm not going to address whether there's verified proof or not of jurisdiction,
Because
whether
it's not.
there's anything along those lines. It is frankly not required under the law. You may disagree with that. You can take that up on appeal, whether that's an interlocutory appeal or whether that's a direct appeal if there is a conviction. But I'm not going to address it.
Because there's no verified proof.
There does not need to be, sir. All right, I
It does
believe the
need to
jury
be.
is coming out. Is that true?
In order for a case to...
All right. The
To
record
go
should
on, there should
reflect
be
that
proof.
the jury is coming out, and we are about to continue with the state's next
Not once
witness.
was the plaintiff addressed. That wasn't addressed. Where's the plaintiff? Where's the injured party? That's because
The jury will disregard the statements presently being made by the defendant.
Because y'all don't want the jury to know the truth.
The jury will disregard those statements
understand.
made by the defendant.
I see.
It is not his opportunity to testify. They are comments, and as such are to be disregarded.
I see what's going on. Ain't gonna work.
All right. Thank you, everyone. You may be seated.
It's not gonna work.
Is the recording that your daughter captured that afternoon?
Yes,
And same recording that you turned over to the Waukesha Police?
yes.
All right. Move to admit number 139 and permission to publish.
Objection.
Thank you. I don't have any other questions. Mr. Brooks may have some questions for you.
Any cross?
Yeah, and I object to being called that name again, and I don't consent to it again for the record. Just a few questions. Do you recall about what time you arrived at the parade that day? Do you recall how long you were there before the parade actually started to get underway? And who all were you with during the parade? Were any of you or your family injured? Do you recall seeing a vehicle approaching? About how far was it from you when you saw it approaching? Did you see the vehicle strike anyone before that point? Do you remember the large crowd? Do you recall it being pretty loud at that point?
Every parade I've been to has been loud in general, so
So it'd be fair to say that one was pretty loud. Do you recall what you did when you saw people being struck? And do you recall how long you were in the karate studio? Was it briefly, or did you hear at any time a report of shots fired? Did you hear any shots?
I can't say for sure if I heard shots or not.
So would it also be fair to say that if a horn may have been blowing, you wouldn't have heard that either?
I would have heard a horn.
So it'd be fair to say that you think you would have heard a horn, but not shots?
I didn't hear any shots when the car went past.
No, I'm not asking when it went past. I'm saying the question was at any time. Any time during that moment.
I've never heard a gunshot before.
So it'd be fair to say you wouldn't really know what a gunshot would sound like. Seeing as how you've never heard a gunshot before, would it be fair to say that it might be really loud?
Yes.
Do you recall if it was any music playing coming from any of the vehicles in the parade? Do you recall about what time you and your family left the parade? You recall making a statement to law enforcement at any time during the incident? After the incident, the days after?
When I sent the video in to the police, is the only time I talked to anybody about this.
Do you recall when that was that you sent the video in? Was it a few days after the incident, or a week or two? Or were you contacted by law enforcement about any follow-up to the video? Did you follow up with law enforcement about the video? And I'm assuming at some point you took that video off of your daughter's phone. Would that be fair to say?
Correct.
Did you post that video footage anywhere, social media or anything? So it was just only to law enforcement that the video was shown?
Correct.
Never showed it to any other family members or friends at any point?
Objection, relevant.
Grounds. When were you notified that it was a possibility that you may be called to testify in this matter?
August, I think.
So not that long ago then would be accurate, or pretty recently rather. Do you recall if that was in subpoena form? Did it state by whom the subpoena was sent?
The district attorney's office.
Did it have a name?
Susan?
Did you contact the district attorney's office after receiving the subpoena? So at the time of October the 3rd, when you did a check to see if you would be needed, is it fair to say that at that time you wasn't sure if you would be testifying or not? Did you seek to testify in this matter? Did the district attorneys ever tell you in any way that they were the plaintiff in this matter? Are you aware of any plaintiff in this matter?
Objection.
Grounds.
Irrelevant.
Grounds.
Sustained. You don't have to answer that.
Grounds for the sustain, Your Honor. Did you or your husband or anyone in your family that was present at the parade file any claims on the matter?
With who?
At any time, did you file a claim with any, I guess, the agency or anything like that?
No.
In regards to the incident?
No.
Did any information that you obtained in regards to this incident have a complaint with it?
Objection made.
Grounds.
Sustained is to the form of the question.
Have you ever seen any complaint related to this incident? Grounds.
Sustained is to the form of the question.
Do you know of any complaint with this incident?
What kind of complaint?
Have you ever seen any issued charges in relation to this incident?
I'm sorry.
Grounds?
I did not understand what Mr. Brooks just asked, Your Honor.
I believe he said the issued charges.
I object to that on relevance grounds, Your Honor.
Grounds?
Overruled. She may answer.
I haven't seen a list of the charges.
I was referring to if you had received anything from the district attorney's office about the charges issued. Are you aware of anyone bringing any claims or suits?
Objection.
Grounds?
Irrelevant.
Grounds?
Sustained. You don't have to answer that.
Grounds for the sustain, Your Honor.
Next question, please.
Do you recall seeing the driver of the vehicle that you saw that? Could you see if anyone else was in the vehicle that you saw? Can you recall if you saw any tents to the vehicle you saw? And by tents, I mean like tinted windows or anything of that nature. Do you recall where the vehicle traveled after it passed you? So you didn't observe anyone struck after what you saw initially. And you stated that you haven't really been keeping up with the incident, right?
Correct.
So that would that mean that it was your choice to do so, or you just kind of just disregarded it?
Objection.
Grounds. Grounds.
Sustained.
Grounds for the sustain, Your Honor.
Next question, please.
After turning in the video to law enforcement, did you keep the video at that point?
Objection as an answer.
Grounds.
Overruled. She may answer.
There's a copy on my phone that is still on there in case I needed to resend in the video.
So pretty much just keeping it just in case.
Correct.
Have you viewed it since turning it into law enforcement?
Objection.
Grounds.
Relevance.
Grounds.
It's been asked. It may not have been asked, but she answered it.
So it'd be fair to say that seeing the video today would be the first time that you saw it since turning it into law enforcement?
Correct.
Just for clarity, you are not aware of any plaintiff in this matter, correct?
Asked and answered.
Grounds.
The
Is that an objection?
objection is sustained.
I think you said that you were contacted back in August, correct? Do you recall before August being contacted in connection with this incident?
Objection.
Grounds.
Repetitive. Irrelevant.
Grounds.
Sustained.
Grounds for the sustain, Your Honor.
Next question, please.
No grounds. Would you consider yourself an injured party in this incident?
Objection.
Grounds.
Repetitive. Irrelevant.
Grounds.
Sustained.
Reason for the sustain, Your Honor.
Next question, please.
No further questions.
Any redirect.
No, Your Honor.
You recognize the diagram on the screen in front of you?
I do.
What is it?
That is the scale diagram that I created as a result of the Trimble measurements that I took out at the scene.
I move Exhibit 56 into evidence and request permission to publish.
Objection. I can't see it on my screen.
He's right.
We came up with the speed of the vehicle, or average speed of the vehicle during that segment of 32 miles an hour.
32 miles an hour as an average speed from point A to point B as they're depicted on this diagram.
Correct.
Witness.
And in terms of this case, you used a 2010 red Ford Escape.
Correct.
Okay. Do you happen to know the curb weight of that vehicle?
Yeah.
Okay, I want to wrap up by just asking you some clarifying questions about the nature of what an average speed means. Can you say definitively that at any point between point A and point B, the vehicle was traveling faster than 32 miles an hour?
Objection, hearsay.
Overruled. You may answer.
Grounds.
So,
From your testimony, it seems like you've been doing crash reconstructions from quite some time. Is that fair to say? Around 2004, I believe you said. You stated that you worked with detectives in the process. Do you recall who that was? On getting the calculation of the speed, did you work with anyone on that side of your investigation?
no.
So it was pretty much just you and the detective. I think the exhibit showed the building that had the camera. Do you recall which streets that were along the parade route? And the point A and point B, did those start from a cross street, or was it just the main? You made reference to the distance traveled in feet.
Correct.
I think it was 141. And you made a reference to the average speed. Any reason why the average speed wasn't depicted in the exhibit?
I don't normally do that in the diagram.
So it would be fair to say that you created the diagram? You said normally you don't put the speed calculation in the diagram. Would it be any reason for that?
It's not necessary to put it in the diagram.
Have you ever done that before?
Could you rephrase the question?
Have you ever not included the speed analysis in any crash reconstructions that you've done before this one?
Are you referring to the diagram or are you referring to the
Referring
report?
to the diagrams.
No,
I'm
I
sorry.
don't. I do not put speed calculation results in diagrams
On any of them.
on any of them.
Did you create any diagram with the speed calculations present on it? And then from there you put the speed calculations just in the report. Would it be fair to say that it may be a little bit difficult to locate what you analyze for speed if it's not in the diagram? So if you wanted to know the calculation of the speed, you would have to read the report. Would it be fair to say that it might be easier to find if it was included in the diagram? Can you explain what the S6 is?
The S6 is the name of the Trimble robotic total station that we use to actually measure things at crash scenes.
So that's like a certain technology or something, would that be fair to say? And what is a prism? Is that in direct relation to the electronic distance measuring system? And that prism's pretty accurate, you would say.
Well, the unit is accurate.
And is the CAD the diagram that you created?
Could you rephrase the question, please?
Is the CAD, is that software related to the diagram that you created?
It is.
In what way? Can you explain what the 2.4 gigahertz radio technology is? And is that communication radio?
Yeah, there's a radio inside.
You made reference to something called Newton's law. Can you explain a little bit further what that is? I always thought of Newton as gravity, so that was a bit of new information. You made reference to part of the crash reconstruction was finding a similar vehicle. Would that be fair to say? And you were able to find a similar vehicle pretty easily, you would say? And you made reference to it being in the parade as well? Or part of the parade as well?
The exemplar vehicle was not in the parade.
I may have misinterpreted what you were saying. And you said it was found by the Waukesha Police Department.
Yes, sir.
You recall if that part of your investigation and the creating of the graph and all that technology that goes with that, was that part of the same day or were they done on at different times? It seems like a lot of technology went into getting the diagram created and different variations of that, and then also using a similar vehicle to, I guess, simulate would that be fair to say, simulate the incident? Was that done all the same day, or was it done
Sorry,
at a
could you
different
rephrase
time?
the question again? I'm not understanding what you're asking.
Was the creation of the diagram and the simulation of the vehicle done on the same day?
No, it was not.
So it'd be fair to say it was a process involved in getting all the information.
Correct.
And you stated that was done around January 30th, around that time. And what about the simulation from the similar vehicle? You recall what date the simulation was performed? Specifically the part of the similar vehicle being used. What part of the process was done at a later date? Do you recall the date of the second part of the investigation?
Are you referring to when I completed my reports?
Yes.
No, I don't know what day that was.
Was it sometime after the January 30th date? Would you say there was a delay in finishing it, or did something cause you to kind of, let me rephrase that. Was there anything that may have delayed you finishing the investigation quickly?
What do you mean by quickly?
It seems like there was two parts of it, getting the simulation done and then the actual diagram and things of that. Any reason why that couldn't be done closer together?
Well, first of all, it's not a simulation. There's nothing that delayed my report. No delays that would affect the outcome of the report or the accuracy of the report.
No, I wasn't going to that part of it. I was just kind of curious to what may have spaced out the dates. That's what I was really getting at. No further questions.
Did you perform an external examination of an individual identified as Leanna Owen?
Yes.
And can you just state for the record how many pages that autopsy protocol consists of?
It's not on the screen.
And it's not going to be on the screen. Provide Mr. Brooks a copy of of both the autopsy protocol as well as the diagram that's going to show on the screen.
Since it being called that name, Your Honor, for the record.
I would ask the court to accept Exhibit 62 and 163 into evidence.
Objection.
And in performing the autopsy procedure on Miss Owen, what was the cause of her death?
Multiple blunt force traumatic injuries.
Specifically for the injuries that she sustained, can you describe the fatal injuries for the jury?
Objection, leading witness.
Overruled. She may answer.
Leanna Owen had injuries to her head, spine, torso, and viscera, or her internal organs. The combination of all these injuries led to her death, but she did sustain isolated injuries to her upper cervical spine, or her neck spine, and aortic lacerations. The aorta is the largest artery in the body. That would have been fatal within seconds to a couple of minutes.
And would all those injuries be consistent with being struck by a moving SUV weighing approximately 3,300 pounds?
Objection, hearsay.
Did you perform an autopsy on an individual identified as Virginia Sorensen?
Yes.
Is that a summary of your findings from the autopsy protocol for Ms. Sorensen? I would ask the court to admit Exhibits 164 and 63 and publish 164.
Objection.
The autopsy protocol for Virginia Sorensen as well as the diagram contained in 164 have both been provided to Mr. Brooks.
Objection, I don't consent to that name, nor do I agree to it.
Did you perform an external and an internal examination of Ms. Sorensen?
Objection, leading the witness.
And during the autopsy, what injuries did you discover on Ms. Sorensen?
Virginia Sorensen had blunt trauma to her head, neck, torso, and right leg.
Were you able to determine a cause of death for Ms. Sorensen?
Yes, multiple blunt force traumatic injuries.
Can you describe for the jury which injuries were fatal injuries?
Virginia
Objection, leading the witness.
Overruled.
Virginia Sorensen also had a high cervical spine injury with laceration of her brainstem. She also had lacerations to her heart, either of which would have been fatal.
And is that consistent with being struck by a moving SUV weighing approximately 3,300 pounds?
Objection, hearsay.
Finally, Dr. Shield, did you perform an autopsy on Jackson Sparks?
Yes.
And I'm going to display what's been marked as State's Exhibit 165 on the screen in front of you.
Objection, I'm confused. 64 or?
They reference both.
Oh, okay.
64 is the protocol, 165 is the diagram.
Okay, I was a little confused.
And for the record, the state did provide Mr. Brooks with a autopsy protocol for Jackson Sparks as well as a copy of Exhibit 165, which is the diagram. Ma'am?
Objection, I do not consent to that name, nor do I know that individual.
I would ask the court to admit State's Exhibit 64 as well as State's Exhibit 165 into
Objection.
evidence and publish Exhibit 165.
Objection.
When did you do your external and internal examination of Jackson?
November 27, 2021.
Why was that later than the others?
Jackson went to the hospital. He was pronounced brain dead on November 23rd.
And again, is there any reason why it would take till the 27th to perform the autopsy?
Objection.
He was
Hold on. Overruled. You may answer.
Jackson was in the hospital. He became an organ donor, which often requires a couple of extra days.
Can you describe for the jury his injuries?
Jackson had bruising around both of his eyes. He had a large bruise to the left side of his forehead. He had undergone a craniectomy where the neurosurgeon removes a portion of skull to relieve pressure on the brain from brain swelling. That's the large oval depicted on the left side of the skull in the diagram. He had trauma to his brain. He had bleeding around his brain inside his skull. He had multiple bruises to his brain. He also had a separation of his skull from his cervical spine, and he had 2 rib fractures on the right side.
What was his cause of death?
Complications of craniocerebral injuries due to blunt force trauma to head.
And what injuries of those were fatal?
His head injuries.
And would that be consistent with it being struck by a moving SUV weighing approximately 3,300 pounds?
Yes.
Objection, hearsay.
Nothing further, Your Honor. Thank you.
Do you know why the decision was made to why the decision was made Jackson to become an organ donor?
Objections or relevance?
Sustained.
Did you end up doing any more autopsies beside those 3? As far as this case, those are the only 3 autopsies that you did? Can you recall when they were brought to the hospital?
Virginia Sorensen and Leanna Owens were pronounced at the scene. Jackson Sparks was transported to the hospital.
I'm assuming that's Waukesha Memorial.
He was transferred to Children's Hospital of Wisconsin.
Upon first tending to the victims, were you in the knowledge of what happened? And that knowledge was given to you immediately when you were called to tend to them? Were you called to tend to any other victims of the incident, or just the three?
Jackson Sparks, Virginia Sorensen, and Leanna Owens.
You didn't tend to anyone else?
Objection asked and answered.
Browns. No further questions. Your
Save a
Honor,
call. Sorry.
Your Honor, if it pleases the court, may I have a few moments?
We can take a short break. I'll excuse the jury. We all can take about a 10-minute break. All rise for the jury, please. We have ample time, from my perspective, set aside for this entire case, even if the state believes they're a little bit behind.
And to that extent, Your Honor, we feel like we're catching up a little bit here today.
Mr. Brooks, any statement or comment based on the requests that have just been made?
No comment. Just briefly touch on the subject matter jurisdiction.
Can you describe for the jury, well, first of all, when did you perform the autopsy on Mr. Rand?
On November 23rd.
And were you aware that this was as a result of an incident that occurred in downtown Waukesha on November 21st, 2021?
Absolutely.
Overruled.
What were your findings with regard to Mr. Rand?
She had two groups of injuries, I like to say. One is from the impact of the car with the body, and these injuries include the marks on her hips that you can see on the posterior.
And I'm just going to ask the court, I apologize, permission to admit Exhibit 166 and 59 into evidence, and permission to publish 166.
Objection.
Objection is noted. It is overruled.
I apologize. If you can start over with that testimony, they didn't have the diagram in front of them.
And those points of contact resulted in fractures of the pelvis on the right. So the car struck her hip, broke her pelvis. The impact of the car with the body pulls the foot out of this shoe. This is very characteristic of a pedestrian injury because of the force and velocity of that impact. A line on the skeleton diagram across the skull, which is a fracture from ear to ear at the base of the skull, and two fractures in the occipital area or back of the head, which you see in the posterior skeleton, which extend basically to the base of the spinal cord. Internally, corresponding to that impact with the ground, there was subarachnoid hemorrhage, or hemorrhage covering the brain, and also a tear at the level of the brainstem from that impact. And as a result of the impact that caused the fractures, there were also contusions of the lung bilaterally on the inside, and hemorrhage, we call retroperitoneal hemorrhage, which is the area around the kidney on the right side. So there are two groups of blood trauma.
I think it's hard maybe for the jury. I'm having a hard time seeing some of the dots
Okay.
on the skeletal diagram.
Objection. Relevancy it is.
Overruled.
Grounds for the overrule.
Briefly point to what you testified to.
Objection. Action answer.
Overruled.
What is the significance of those measurements? You had talked about the height of the car. Did you see the suspect vehicle, or did you go to look at the suspect vehicle in this case?
Yes, I did.
Overruled.
She died of multiple blunt trauma, but each area of injury was quite severe in and of itself.
Would that be consistent with her being struck by a moving SUV weighing in excess of 3,300 pounds?
Absolutely.
It's overruled.
Moving next to the autopsy that you performed on Jane Kulik, I would ask the court to admit State's Exhibit 61 and admit and publish 167.
Where's 61? Objection. Where's 61?
You should have that. It's not been on the screen. It was provided to you previously.
That'd be the autopsy protocol for Jane Kulik. What did you determine the cause of death to be for Ms. Kulik?
Multiple blunt trauma.
And the fatal injuries, can you describe those for the jury?
Her injuries from being run over were probably the most severe, with the multiple rib fractures and the crushing of the liver. Also severe, however, was the pelvic fractures, and then the rib fractures, the chest injuries, the pelvic injuries, and the abdominal injuries. Each were very serious, could have been fatal individually.
And is that consistent with Ms. Kulik being struck by a moving SUV weighing in excess of 3,300 pounds?
Yes.
Finally, ma'am, I'm going to direct you to the autopsy protocol for Wilhelm Hospital. I'd ask the court to admit Exhibit 60, which is the autopsy protocol, as well as the diagram contained in Exhibit 162.
Objection.
Noted, it's overruled.
Unlike the other two people that you had performed autopsies on, were those people brought to the medical examiner's office from the crime scene being Main Street?
Objection. Leave the witness.
And can you describe, or did you determine the cause of death to be for Mr. Hospital?
Multiple blunt force trauma.
And the fatal injuries for Mr. Hospital, can you describe those for the jury?
Objection. Answer.
Mr. Hospital's most severe injuries were related to his pelvic injuries, which he lost a lot of blood. They required to put a coil to try to obstruct the bleeding vessel to stop it from bleeding. It was not accessible surgically. You had to put like a coil through the vasculature. But also the impact here caused an injury to the thoracic duct, which carries your lymph fluid. And as a result of that injury, he also had an accumulation of fluid in both chest cavities of the lymph fluid that occurred during the hospital course, which impaired his respiratory status. So it's an indirect cause of the injury, the accumulation of the fluid, but they both are related to the impact of the vehicle. His head injuries, it's harder to assess because he died. He did present with a change in consciousness, so it's possible those head injuries would have been independently fatal.
Those be consistent with being struck by a moving SUV weighing in excess of 3,300 pounds.
Objection. Leave the witness.
Nothing further, thank you.
Any questions for this witness?
I do. Your primary field is in the medical field. Would that be fair to say? Any reason why you would be inspecting a car if that's not a medical professional thing? So examining the vehicle would be important to your medical assessments in what way? So it would be fair to say you've done numerous autopsies in your time as a medical professional. Would that be fair to say? And as you just said, examining the vehicle would be essential to your medical expertise. Is that fair to say?
Examining the vehicle is important to interpret the injuries.
If you were doing an injury assessment based on if the injury was caused by a different kind of instrument, would the same apply to having to view that?
Yes, if in cases of gunshot wounds, I asked to see the gun.
It would be fair to say if in a case of a gunshot wound, as you brought up, let me back up. Would you say it would be hard to assess the gun, being that it wouldn't be the actual gun, but the bullets that caused the injury?
Well, actually, I don't examine the bullets, but I would examine the gun, especially, for example, if it's a contact wound. So if the muzzle of the gun touches the skin, then the muzzle could leave a mark. So then I could say the muzzle of the gun shown to me might match the mark.
And if it was something similar to that, the muzzle type thing, the mark would be from the heat. Would that be fair to say?
No, not actually. It's more of an abrasion than a burn.
So in a case like that, what would be the significance of the actual inspection of the gun?
I'm going to object to this question. I think it's a little bit afield of where we're at.
Grounds.
Overruled. She may answer. She brought it up.
What would be the significance in a case like that? As you stated, you view all types of instruments, gunshot wounds and things of that nature. What would be the significance of inspecting the actual gun in terms of the injury? So what if it was used from a distance? Then what would be the essential reason to inspect the gun?
Distance does play a role on what I would be evaluating.
Do you know if at the time you did the autopsies, if any of victims you performed the autopsy on had any underlying illnesses at that time? Any cancers or anything like that may have been going on at the time that you did the autopsy?
Yes, I would make observations of any natural disease processes that I saw at the time of autopsy.
Did you observe any? Do you recall from who that was? Can you explain to the jury what is a large thyroid? Is that the word thyroid?
Fibroid.
I'm sorry.
Yes. It's
fibroid.
A benign uterine tumor.
Is that a form of cancer?
No.
You said the older gentleman had some fluid buildup in the chest. Correct me if I'm wrong. I don't want to misquote you. Some type of fluid around the chest area.
Correct.
From your recollection, that wasn't caused by the vehicle.
That was.
So that it would be fair to say that came about once he was already at the hospital. And you said he had a pacemaker. Would that have any effect whatsoever on what might have been going on in his chest at the time?
No.
Was it pretty active, still working properly at that time?
It was.
Even with the loss of blood, as you say, he had a loss of blood. Even then, was it still working pretty good?
The loss of blood had no effect on the electrical function of the pacemaker.
Were you at the parade at the time of the incident? So at the time you were called, did you know any information about the incident?
Yes, I was informed about the death of numerous people, injuries of more, and that this was a result of a car going through the parade.
Do you recall if it was referred to as a car or a SUV? And you were already privy to that information before you arrived at the scene? Do you recall whom informed you of that? So it would be fair to say you don't really recall. And you said you observed damage to the vehicle when you were able to view it. Would you say it was extensive damage, or did you really look at one specific area? Or let me rephrase that. Were you really focused on one certain area of the vehicle when you viewed it? Specifically looking at the hood of the vehicle to determine how it fit with your medical expertise? With your expertise, would you determine that all of the damage that you observed would be caused strictly from hitting one thing or numerous?
There were dents, if you will, in multiple areas of the car.
So from your expertise, that could have came from a number of different things. You made a brief observation about speed and velocity. Do you have any expertise in that area? Would it be fair to say that everybody is different, though?
Everybody is different.
So I guess I would phrase the question by saying something that may seriously injure someone else probably wouldn't seriously injure another person based on your expertise.
It was not typically how it is.
But it can vary. Do you recall how many people you were called to attend to the night of the incident? Did you see anyone else besides those three?
I later saw Ms. Coolidge.
So it was just the three?
The four.
And no one besides those four. Do you recall being notified possibly to testify in this matter? Do you know about when?
I knew always that this case would end up in trial.
And how would you know exactly that the case would end up in trial? And I say that because many factors could play out along, many different things happen over time.
Given the nature of the case, but I did not know for sure.
That makes sense. Definitely. So you had an idea that you might be testifying. And when did you know for sure? Do you recall when you were subpoenaed? Was it fairly recent to now, or was it some time ago, a few months? Do you recall whom you were subpoenaed by? Would that be referring to one of the district attorneys here today? Do you recall what time you arrived on the scene after the incident that night? And do you recall what time you finally left the scene? Would it be fair to say you were there for quite some time? And after you were subpoenaed, were you in contact with Attorney Opera after that? Did Attorney Opera ever state that she was the plaintiff in this matter?
Objection, relevance.
Sustained.
Grounds for the sustain, Your Honor. Were you ever made aware of the plaintiff in this matter?
Objection,
Grounds.
relevance.
Sustained.
Grounds for the sustain, Your Honor, before I continue.
Ask your next question.
Do you even know if there's a plaintiff in this matter?
Objection, relevance.
Grounds.
Sustained.
Reason for the sustain, Your Honor.
Ask your next question.
No reason for the sustain, Your Honor.
Ask your next question.
Do you know of any claims filed in this matter by you or anyone else?
What are claims?
Any reports filed? Any filings made on your behalf or anyone you know?
I'm actually not sure I understand that.
I would object to it. It's vague.
Grounds.
Sustained.
Did you make any claim of being an injured party in this matter? Do you know of anybody that has?
Objection, relevance.
Grounds.
Sustained.
Reason for the sustain, Your Honor. Have you had any opportunity to view a complaint in this matter?
Objection, vague.
Grounds.
Sustained as to the form.
Have you ever seen a complaint in this matter?
Objection, vague.
Grounds.
Sustained.
Have you ever at any time had any interaction with the plaintiff in this matter?
Objection.
Grounds.
Sustained.
Reason for the sustain, Your Honor? I would object to that sustain. You said vague and relevant to the
Sustained.
case.
Next question, sir.
Relevant, Your Honor. Jury deserves to know.
It's overruled.
I respect that. Jury deserves to know, though. Have you ever seen the plaintiff in this matter?
Objection. Relevance.
Grounds.
Sustained.
Reason for the sustain, Your Honor?
Same as before.
So that would be relevancy and vagueness.
Ask your next question.
Was today your first time ever seeing those exhibits that were shown? You've seen those before, those videos?
Videos?
Yeah, the exhibits that were shown. The
Diagrams?
yes. I'm sorry, I didn't know that's how you identified them.
Oh, well, I drew them.
Oh, those exact ones?
Yes.
Oh, so okay. And so I'm assuming at some point you turned those over to the district attorney. Would that be fair to say?
Today.
Oh, today. Any reason why you didn't previously turn those over before you actually were called to test, or before you knew that you would be testifying today?
They didn't exist before today.
That's interesting. So this was really like a 11th hour, bottom of the night thing for you to get them prepared and be ready to go today then. Would that be fair to say?
No, I wouldn't say that.
So how long did it take for you to detail them? So would it be fair to say that you have been working at this for some time then to get it the way you...
A few days.
Did you anticipate that you would be using those diagrams? So I'm assuming that some type of conversation had to be had in order for you to work that hard on those diagrams. And you had that conversation with Attorney Opper. What would be the reason why you weren't already asked to develop those diagrams? Meaning, why weren't you asked this months ago in advance? Would it be fair to say that you just testified that you didn't know for sure if there would be a trial? Had you ever created any diagrams like that before, or at any time before this particular case?
Are you still you're not referring to these particular cases?
These particular, the way that you did these, had you ever done this before this incident?
I use diagrams all the time.
So for this particular case, you decided to go a little bit extra. Would that be fair to say? Grounds.
Sustained.
Would it be fair to say then that for this particular case, you decided that you would want a diagram that was a little bit more defined?
What I decided was we had 3 decedents.
So had you thought of that before in any other cases that you've done before this one?
I don't remember testifying about 3 pedestrians in trial in one sitting ever before.
No. I wasn't asking if you've testified at a trial before. I was asking based on the explanation that you just gave about making it easier to read the diagrams. Had you ever thought of that before this particular case?
It's not unusual for me to create my own diagrams specific to a case.
What I meant by that question was the way that you designed these particular diagrams. Had you thought of doing it this way before this particular incident?
Objections or relevance?
Grounds.
Sustained.
Grounds for the sustain, Your Honor.
Next question, please.
Do you recall when you completed all your medical work for this particular case? So about 8 months at the time that you concluded your reports, were you already thinking about forming the diagrams for the injuries?
No.
So that kind of came about during the process of possibly knowing that you might testify.
The diagrams were created as court exhibits.
Today.
Completed today.
Do you recall what time they were completed today? Was it morning or shortly before you came in, or?
Objections or relevance?
Grounds. No further question.
Are all the findings that are contained in those diagrams from the autopsy protocol?
Yes.
Objection.
Overruled.
Relevancy.
Overruled.
But could you have brought in a skeleton and described the same injuries?
Objection. Relevancy.
Overruled. It's
Objection.
recorrect.
Hearsay.
It's not hearsay. She may answer.
And if you had in a doll or a mannequin, that would be something that you could show the jury, just like you did in these diagrams, where the injuries, the external injuries were. Would that be a correct statement?
Relevancy.
Overruled.
So is there anything on these diagrams that were not contained within the autopsy protocol that were turned over to the state months ago?
Objection. Relevancy.
Overruled.
If I put a blank diagram in front of you, could you have made these same markings right here? And it would have just taken time, obviously, but could you have done it right now?
Objection, lead the witness.
Overruled.
You had stated that you had discovered a benign uterine fibroid. Is that correct?
Correct.
Did that in any way, was that a factor in her death?
Objection, hearsay.
Overruled.
And with regard to Wilhelm Hospital, was the presence of a pacemaker in any way related to his death?
Objection, I asked that in my cross and she answered.
Overruled.
The coronary disease that you testified to on cross-examination, did that play a factor in his death?
Objection, same reason.
Overruled.
Already
You may
answered.
answer.
The thoracic fluid found in Mr. Hospital's lungs that you said did play a factor in his death. Is that correct?
Yes.
What caused that fluid buildup around his lungs?
Objection, answered already.
Overruled.
Nothing further, thank you. Are you familiar with pretty much everyone within this picture? I would ask the court to admit Exhibit 129 into evidence and publish it for the jury. Would ask the court to publish.
The objection is overruled.
Can you briefly kind of go over the people who are named and their relationship with the other people in this picture? How about Adair Lopez Revelar?
Objection, leading the witness.
That appears to be the street that you guys
Exactly.
walked on
Yep,
and the clothing
definitely.
that he was
Objection,
wearing.
leading the witness.
Overruled.
And I'm sorry, that accurately reflects what you believed you would have seen on November 21st of last year.
Yes.
I would ask that Exhibit 128 be admitted into evidence and published to the jury.
Objection.
Specifically, since we've identified the other people in this photograph through Exhibit 129, that is Jason Peckloff, and he's correctly named in this diagram.
Yeah, definitely.
Objection. Everybody was not positively identified.
Your Honor, I'm going to move Exhibit 121 into evidence, ask that it be published. Father Witter indicated that Jose Perales Alvarez and Juan Marquez, it would be consistent, but he cannot say with 100% positivity that those are those two individuals.
Objection. It was not said with certainty whatsoever. The answer was he's not sure.
And there are two names associated with two individuals on this picture. Can you positively identify that those individuals are the people in this picture?
Objection, leading the witness.
Overruled.
Can you identify the individuals who are named in this exhibit?
Objection. The names are on there.
So
That's a big arrow pointing to there.
your objection's noted. It's overruled.
I'd ask the court to admit Exhibit 123 into evidence and to publish it for the jury.
Objection, relevancy.
States Exhibit 124. Do you see the name of Elliot Hallmark and Father Pat Heppy?
I do.
And are the arrows associated with the people that you know as Elliot Hallmark and Father Pat Heppy?
Objection, leading the witness.
I would ask the court to admit Exhibit 124 and publish it for the jury.
Objection, relevancy.
And finally, I'm going to show you what's been marked as Exhibit 125. I'd ask the court to admit Exhibit 125 and allow it to be published for the jury.
Objection, relevancy.
What, at some point, was your attention drawn to something during the parade? Something unusual?
Yeah, so we were all of a sudden kind of heard a scream. My experience was I turned to my left and there was a red SUV just flying down the road. Should be kind of hearing it, kind of striking people.
And I'm going to just, because we have to put that on the record, that you put your fist to your palm of your hand, making a striking noise.
Yep, just kind of like a
Objection, leading the
pounding
witness.
sound, I guess you'd call it.
How many times did you hear that?
So for
Objection,
me,
leading the witness.
Overruled.
I'm going to show you what's been marked and admitted into evidence as States Exhibit 15. It'll not only be, I'd ask that it be published as well.
Go ahead. Exhibit received.
Objection, how many times do you need to publish the same picture?
And do you
And,
see your group on this map?
I do.
Would it be in the left-hand side of Exhibit 15?
Objection, leading the witness.
Sustained. Hold on. Sustained. Please rephrase.
And that would be, in that arrow, or I'm sorry, that star that you circled, then is attached to a list of names. Is that correct?
Objection, leading the witness.
Is there, do you see a list of names and an arrow on that map?
Objection, leading the witness.
Overruled.
Where does that, do you recognize the names that are on that map?
Objection, leading the witness.
Overruled.
Approximately how many names are on that list?
Objection, leading the witness.
Overruled.
And were all those people, to your knowledge, injured as a result of being struck by or indirectly struck by the vehicle in the parade?
Objection, hearsay.
Did you hear the impacts first, or did you see the red SUV first?
I saw the red SUV just flying on the left side. I mean, flying is a relative word, but it was, going fast. It was going faster than anyone in their right mind would be driving in that scenario.
Could you estimate the speed?
Objection, hearsay.
The car, in my estimation, was going faster than I would see a car driving in normal times down that street.
So in excess of 25 miles per hour?
Objection, hearsay, leading the witness.
So the three people you had direct contact with would have been Maria Perez, William Mitchell or Bill Mitchell, and Father Heppy.
That's correct.
Objection, leading the witness.
Let me know, and if you know that they were injured. Maria Alvarez Dominguez.
Objection. It's hearsay.
It's not hearsay. It's asking about his knowledge, not what he heard. It's
The
so you may
injuries
answer
would
the
be
question.
hearsay.
And how about Gregorio Romelia Perez?
She was very, very, very severely injured. Major issues.
Could you observe what those injuries were?
Objection, hearsay.
Jason Pekloff.
Objection, hearsay.
Yamilet Perales Alvarez.
Objection, hearsay.
Jose Perales Alvarez.
Objection, hearsay.
And Camila Perez Gonzalez.
Objection, hearsay.
Nothing further. Thank you, Father.
Any cross-exam questions for this witness, sir?
I do. I don't have too many questions for you, Father. Do you recall when you knew for sure that you would be testifying in this matter? To the best of your knowledge, do you have any reason why you would be testifying on behalf of an injured party if you are not an injured party?
Objection.
Grounds. You testified to observing quite a few injuries. How can you assess the injuries just by looking at the people?
Like, what are you getting at?
For example, if I was to see someone injured laying on the ground, I could essentially say, "Oh, it looks like this." Mm-hmm. But how can I be certain that that's what it is? So my question is, being that you observed a lot of injuries, how are you able to assess what they were just by looking?
Well, the question mischaracterizes his testimony.
How did you know the injuries just by looking?
It still mischaracterizes his testimony. He was asked about whether he was aware.
Yeah, that he observed injuries. So how could he know
He observed some, so you need to be specific as what point in
the
time.
injuries that you saw at the hospital? How were you able to say for sure what those injuries were just by observation? So would it be fair to say that you were told those injuries either by medical professionals or by the people?
Exactly. So if people would say, "This is my injury," I would believe them.
But you didn't know for sure yourself until you were told.
Yeah, I'm not a doctor.
Do you know, because you testified to seeing those, some of those people after the incident, would that be fair to say? Do you know if any of the people you saw after the incident filed any claims in the matter to be an injured party in the matter, or did they file for any medical bill support or anything of that nature? To your knowledge, can you explain to the jury what you mean by the support that you are referring to? Was that like a group formed, or was that sort of like an event of a GoFundMe account or something like that? Can you give some clarity on that? And by international, that would be assuming worldwide. So it would be fair to say that there were financial interests attached to this incident.
Objection is how it relates to this witness's testimony.
Grounds.
Sustained.
Well, it was actually because he referred to some GoFundMe's being set up and anything. So my question was, being that it was a wide-ranging scope by him saying international, was there any financial interests attached to this incident?
And I'm going to object for the same reasons before.
Grounds.
It's vague.
Any idea how much money was raised for the, I guess I would say, GoFundMe's, groups, support?
Objection is a resistance.
Grounds.
What GoFundMe's reached, what the Waukesha Foundation Fund reached, I don't know. But I know the Catholic Community of Waukesha was $73,000.
Did that go straight towards the victim? You stated you didn't see the vehicle approaching at the time when it got to where you were. Would that be fair to say? About how close to you did the vehicle come?
The vehicle was on my left side, very close to when it was on me, I would say, to my left.
So you were on the right side of the street at that point?
It was on the right side of the road.
So it'd be fair to say it was on the opposite side of the road from you. Did it come pretty close to you at any time when it was passing you?
The car did not hit me.
You referred to it as a car, as you just said. Was it a car? Was it an SUV? What was the vehicle?
But as an SUV, to be specific.
Any reason why you would say car?
Objection argument.
Grounds. Well, it'd be fair to say you wouldn't call a bus a car, though, right?
Objection argumentative.
Grounds.
That's argumentative.
When asked earlier, when you were asked about if you saw anyone else on the ground or something to that effect, you said as time went on, you had observed someone else laying on the ground. Can you explain what you mean by as time went on? Was that a significant time that passed, or a very short time that passed at that point? Did you observe the other pockets of people that weren't with your group being struck at any point in time?
At the time of the incident, I had no idea what had taken place behind us.
And would it be fair to say you had no idea what had taken place in front of your group?
Only saw what I saw.
At any time when the vehicle was passing you, were you able to see into the vehicle? But you can't estimate a good speed that the vehicle may have been traveling.
The vehicle was traveling faster than I would usually see a car traveling down Main Street.
So would that be that you said traveling faster than you would see a car traveling down Main Street? Would that be in terms of if there was a parade actively going on, or even without any traffic on Main Street?
If I was at Main Street right now watching cars go past, if I was just on the sidewalk, I would say that the parade was traveling faster than those cars would be traveling.
I'm saying in terms of even if there was no parade, if it was just a normal day.
That's what I'm saying. On a normal day, the car was traveling, in my estimation, faster than you would see a car traveling on a normal day.
And you weren't able to get any description of the driver of the vehicle? Could you at any point tell if there was more than one person in the vehicle? Do you recall being interviewed by any law enforcement at that time? So very brief, not extensive, long extensive type interview, but very brief, just a few questions. Did you give any, or were you interviewed by any law enforcement after that night?
I was not interviewed until getting a subpoena.
Do you recall when you received that subpoena? Were you in contact with any law enforcement about this incident leading up to the October 1st subpoena that you received?
Not before I talked to the DA.
And do you recall what DA that was?
Susan.
May the record reflect that there was a right-hand gesture towards the prosecution table? And was that October 1st time the only conversation you had with Attorney Opper?
Sometime in the month before, we spoke once.
But in the month before the October 1st subpoena?
It would have been sometime in September where I was notified to come in and talk to the DA. So I talked to the DA once.
And at that time in September, you weren't yet subpoenaed?
I was told to come in and talk to the district. I'm not sure if that's a subpoena, but I believe it would be more than come in if you want to.
No, that's not a subpoena. The subpoena is when you actually get the subpoena paperwork by mail, or I don't.
Mr. Brooks, you need to ask a question.
Can I get to it, Your Honor?
No, because you're trying to define something.
Something else. Wow.
Mr. Brooks, that was inappropriate. Do you have any other questions for this witness? Please ask them.
During your conversations with Attorney Opper, in September and October 1st when you received the subpoena. At that time, were you provided the complaint in this issue? The complaint would be a reference to the charges in this matter. Paperwork that would state the charges.
Objection, Meg.
Grounds.
To me, it was very obvious what this was about.
Did you see at any time any paperwork related to the charges in this incident?
So there'd been the subpoena sheet that would have had your name and any number of different.
What do you mean my name? What are you referring to?
I believe it would have said Darrell Brooks on it.
Are you aware that I don't identify by that name?
Objection, argument.
Sustained.
Sorry.
So is that what your subpoena said? Was that the language of your subpoena? The logistics?
We've been down this road under 906.11, Mr. Brooks. You're not, I need you to ask a relevant question to this witness.
That was relevant. He said what was on his
No,
subpoena.
you've talked at length about the subpoena. So under 906.11, move on to a new topic.
Are you aware of who the plaintiff is in this matter?
Objection, relevance.
Grounds.
Overruled, he may answer.
I believe that you would be, or excuse me, you're the defendant.
I would be the plaintiff?
Excuse me, at my mind. You're the defendant, I believe. The plaintiff would be, all those who were hurt under the title of the state of Wisconsin.
That's how you would identify it. So do you know if anybody who was hurt that identified as the plaintiff?
Objection, relevance.
Grounds. He did.
Foundation.
He did answer the question though.
Sustained.
So to the best of your knowledge, the plaintiff would be the representative of the people.
Objection is relevance.
Sustained.
Do you know of any injured party who claims to be the plaintiff in this matter?
Objection, relevance.
Grounds.
Sustained.
Are you aware that only an injured party could be the plaintiff in this incident?
Objection,
Grounds.
relevance.
Sustained also misstates the law.
How does that mischaracterize the law? An injured party has to make the claim.
Under 906.11, you haven't asked a question. I will give you one more opportunity.
Are you aware that the state of Wisconsin is an entity and cannot claim to be an injured party in this matter?
Objection.
Grounds.
Sustained. All right. Your cross-exam is now closed. Does the state have any redirect for this
Briefly.
witness?
Prior to the red SUV coming through your group, did you ever hear a horn honking?
Objection.
Overruled. You may answer, sir.
Objection. Hearsay.
Now I'm going to show you State's Exhibit 15 again and ask that that be published to the jury. This has already been admitted into evidence.
Go ahead.
Objection. What was the answer to the last question?
The record speaks for itself.
In looking at that box again, were all those people on the road as part of the Catholic Communities of Waukesha when the red SUV went through?
Objection. Leading the witness.
One final question. When you spoke with District Attorney Susan Opper in your meeting that you testified to, did she ever tell you what to say today?
Objection. Hearsay.
You questioned his credibility. You questioned his talking to the state. He may answer the question.
The only
Go
reason
ahead.
why I'm objecting, Your Honor, is because
Your objections noted.
Attorney
It's
Opper is not asking the question, so how would Attorney Basie know what
Mr.
Attorney Opper
Brooks,
said?
I'm not going to explain the legal procedures.
Did she tell you to tell the truth today?
Objection. Relevancy.
Sustained as to the form of the question.
Everything that you testified today, is it truthful?
Objection. Hearsay.
I would like to get through one more witness, but I want to take a short comfort break for everyone, so I'll rise for the jury. Mr. Brooks, not now.
Not allowed to.
Not now. The jury is in this courtroom, and you will show respect for them and for this court.
Respect for them would
Mr.
be
Brooks.
telling them the truth.
Stop. I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Then
That is why
prove it.
your questions
Prove it.
are being
Prove that it's
objected
frivolous.
to,
Prove
and
that it's
why
frivolous. Prove it.
all the cases that we've already referenced, sir. We are in recess. We'll be back
And
in
prove
5
it.
minutes. Thank you, everyone.
I don't agree to a estoppel. Can you prove it?
Attorney Opper, you just wanted to address timing.
We do have two witnesses here ready to go. If the next witness goes relatively smoothly, would you consider letting us call the second one and maybe wrapping up by about 6 o'clock?
Yes.
Thank you. If not, he can come back tomorrow, but he's been here twice already.
No, we'll keep going. I prepped the jury for that yesterday, so we're good. I'm going to have the jury brought out. Bring the jury in, Madam Clerk.
And I object to that.
To the timing?
Yes.
Your objections noted. We're going to make up for lost time from yesterday.
So can we adjust the subject matter jurisdiction?
No,
then,
we
since
cannot.
we talk about that? We're not going to address that either. That's still not going to be proven, right? It is frivolous stuff. That's going to get pressed every time. So, not yet to prove subject matter jurisdiction, any jurisdiction at all, right?
The jury will disregard the comments being made by Mr. Brooks at this time. They are a mischaracterization of the law.
Absolutely not. They are absolutely not. They are.
All right, thank you, everyone. Please be seated. The state may call its next witness.
That was taken on November 21st, 2021.
And there are boxes with names that are associated with people through a red arrow. Do you see that?
Yes.
Overruled, he may answer.
As you review those names and the people that those names are associated with, is that exhibit accurate?
Objection, leading the witness.
Sustain us to the form of the question.
And the arrows, do you see arrows on that exhibit?
Yes.
And they're going from a person to a name. Do you see that?
Objection, leading the witness.
At some point, did you hear some type of commotion behind you?
I did.
Can you describe for the jury what you heard? What were your initial thoughts?
Objection, hearsay.
Have you ever worked a Christmas parade in Waukesha?
I have.
Relevancy.
I don't recall specifically the Christmas parade. I worked other events in downtown Waukesha.
Have you ever worked a 4th of July parade?
Objection, relevancy to this incident.
Are there some times when there are barricades set up and a vehicle will come into the area that they're not supposed to come in?
That does occur, yes.
What would law enforcement do in that case?
Usually stop the vehicle and direct them to either stop or remove them when it's safe to do so.
Have you ever been present where the vehicle doesn't stop?
Objection, hearsay.
When you said that you heard screaming, can you describe for the jury what you mean? Because we're at a parade, so I'm assuming that there's some screaming.
Objection, leading the witness.
Can you describe for the jury if the screaming stood out to you?
Yes,
Objection,
it was.
leading the witness.
And did you notice anything different about your surroundings as you heard the screaming?
Objection. I asked the form of that question and it was answered.
Can you just repeat the question, please?
Sure. Do you notice anything other than the screaming that seemed unusual when that happened?
Objection, different question.
Where were you in relationship to the group that you were walking with?
At that particular time, I was near towards the back, so I would say the middle of the back.
And that's when the vehicle was approximately 200 feet away?
Objection, hearsay.
What did you see next?
It started hitting folks in our group. I had my 3-year-old in my left hand, and I had my 9-year-old in my right hand. My 7-year-old was kind of walking in front of us at the time, and I remember realizing that we were going to get hit, and it was going to come very quickly. And so I grabbed my 3-year-old as hard as I could, and I threw him towards the curb. At the same time, I tried to grab Benjamin at that point and throw him with my 3-year-old.
Oh, Benjamin, is he the 7-year-old?
Yes.
And he was in front of you, you testified?
Objection, leading the witness.
You stated that you had your 9-year-old in your on your right side. What's the name of your 9-year-old?
Elliot.
Objection, relevancy.
When you saw the vehicle and as it was coming towards you, could you estimate the speed that the vehicle was traveling?
Objection, hearsay.
I estimated the vehicle traveling about 30 to 40 miles an hour.
So you threw your 3-year-old to your left, you stated, and how about Elliot?
I don't remember at that point what happened with Elliot. As the vehicle passed us, I don't know if he got ripped out of my arms when the vehicle came through. I just remember that I kind of got, as I turned to my left, I pivoted on my left foot. I got clipped to my left foot.
And when you said you got clipped, what clipped you?
Objection.
Overruled.
Now, in terms of the path that the vehicle was traveling prior to it striking your group, can you describe that for the jury in terms of was it on the north side of the road or the south side? Or, to explain it to someone like me, if you're traveling down the parade route, was it on your left or on your right?
Objection, leading the witness.
As it was coming towards us, so when I saw the vehicle coming, I kind of moved to the left and threw my kids to the left.
And did you say that you had observed anyone get hit that was behind you?
I don't
leading the witness.
I remember turning to my wife and asking her if all the children were okay.
Were there any observable injuries to Benjamin at the time immediately following the car going through the group?
Objection. Leading the witness.
Now, you stated initially when the car was coming towards the back of your group, you thought it may have been someone that just accidentally got on the Christmas parade route, correct?
Objection. That was not the form of question or answer, rather.
Did your thought change at some point that this isn't a misguided vehicle?
Yes.
And what did it change to?
Objection. Leading the witness.
I'm going to show you on the screen in front of you Exhibit 140, and let me know when it's on your screen. I'm going to play the first 5 seconds and see if you recognize this video. Does it accurately reflect what you observed on November 21st, 2021?
Yes.
Objection to the relevancy. Who took the video?
Does this video contain footage of the Waukesha Catholic community in the parade on that date?
Objection. Hearsay.
I would move State's Exhibit 140 into evidence and ask that it be published to the jury with sound.
Objection. Still hearsay.
Young lady, where is your winter jacket?
Did you see a red SUV traveling westbound in that video?
Yes.
Would that be consistent with what you saw coming from behind you on November 21st prior to what you just described?
Objection. How do we know the direction? How do we know it's westbound?
So I'm going to show you some still shots from that video and just ask if they accurately reflect what you observed.
Objection to the relevancy.
What does this photo reflect to you? Sorry.
Objection. Leading the witness.
And are there names on this diagram?
Yes.
And do they appear to be associated with people within this group?
Objection. Hearsay.
How is that depicted?
Objection. Leading the witness.
And do they accurately reflect the names of the individuals that they're pointing, that the arrows are connected to?
Objection. Leading the witness.
Okay, I'm going to ask that Exhibit 135 be admitted and published to the jury.
Objection to the relevancy.
So with regard to this one, if you can just circle Jose Perales Alvarez.
Objection. Leading the witness.
Next, I'm going to do the exact same thing with a couple more pictures. The next one would be Exhibit 136. I'll have it shown in front of you. Let me know when it's on your screen.
Something very similar to the last exhibit.
Is there an objection?
Leading the witness.
And do you see yourself in this photograph?
I do.
I would ask that this 136 be admitted and published to the jury.
Exhibit 136 is received. Permission to publish is granted.
Objection. Where's his name if he's in the video?
Sir, first of all, do you see yourself in this photograph?
Yes.
Can you circle where you're at?
Objection. Why is no name on it? What's the
Overruled.
relevancy of it?
And again, when we're looking at these photos, these are all from the same video. Are they from the same video?
It appears so.
And approximately what location are these taken in relationship to where your group was physically impacted by the car?
Objection. Hearsay.
And would this be consistent with what you believe generally the formation would have been when your group was impacted?
Objection. Hearsay.
I'd ask that Exhibit 137 be admitted into evidence and published.
Objection. Where's the relevancy?
And finally, 128. And do you see the name David Marquez on the screen?
Objection. Leading the witness.
This is a map of the parade route, and it also appears to indicate where certain groups on the parade route that were impacted during this incident.
And is there any type of delineation as to exactly where the parade route, where it started and where it went to?
Objection. Leading the witness.
Do you see a purple line on that exhibit?
Yes.
What does that reflect?
Objection.
Overruled.
Leading the witness.
And are all those people that are listed in that box, were they in the roadway at the time that the red SUV went through your group?
Objection. Hearsay.
And again, it's there's a line with that box that's associated with this a yellow star. What's the significance of that, if you know?
Objection. Leading the witness.
Now I'm going to go to Exhibit 160. Does that accurately depict what occurred near your group, the Catholic community, on November 21st of last year?
Objection. Hearsay.
I'd ask that Exhibit 160 is admitted and published for the jury.
Objection.
The 4 people that you saw sliding through the screen from left to right. Did you recognize those people?
Objection, hearsay.
I'm going to show you what's been marked as 126, which is a still shot from that video. If you can, it'll pop up on your screen. If you can tell me if it accurately represents that video, that still shot from a video.
Objection, leading the witness.
Sir, do you identify each of the people that are shown in this still shot by saying their name and circling their position?
Yeah.
Objection, leading.
One last video. I'm going to play the first 5 seconds for you and ask you if it depicts what you observed on November 21st of last year.
Objection was the relevancy.
Are you able to identify many of the people in this video clip?
Objection, hearsay. There's
Overruled.
a lot of people in here.
Do you recognize the person depicted at 13 seconds?
Objection, hearsay.
And you recognize that to be the position you went to when you found him?
Objection, hearsay. We can't see who that is.
Let me pause here. Do you recognize that person?
Objection, hearsay.
I'm sorry, is that still Marisol?
Objection.
We can pause here.
Pause. Who is that if you know?
So this is still Marisol.
Said objection.
Sir, I'm going to direct you to Exhibit 162.
Okay.
Sir, let me redirect your attention to Exhibit 154 where we were.
Objection. Are we going to another exhibit? You just said 162.
Do you recognize this person?
Yes, that's Eileen Paralis.
And is that how she appeared on November 21st of last year?
Yes.
Objection, hearsay.
And is this a picture taken from a video from the parade?
Objection, hearsay.
I'd ask that the court admit Exhibit 162 into evidence and publish it to the jury.
Objection, hearsay, and relevancy.
If we can save this screen capture, and this would be 162A.
Objection, relevancy.
The same type of hat in terms of has the same wording on it, same color, same palm color as the hat that Eileen was wearing in Exhibit 162.
Objection, hearsay.
Thank you. I have nothing else.
All right, you're crossed, sir.
So you saw all those videos that were shown, all exhibits rather, all 12, 13 of them. You saw all those before today?
I believe there was only 3 or 4 videos, but there was numerous screenshots or photos taken from those videos.
That's why I said exhibit. Have you seen all exhibits before today? And do you know who took any of those exhibits, the videos or still shots?
No, sir.
So how were you able to see them? How were you able to see them if you don't know who took them? Before today, you said you saw them before today. That's what you just said. So I asked after that, do you know who took them? You said no. So how could you, I guess I'm asking, how would you know, if you don't know who took these videos, how were you able to see them before today?
I believe they were collected by the police department as evidence.
And that's how you saw them? Do you know when you viewed them? Did you view all 12 of them in their entirety at the same time, or were they at different dates?
Yeah, back to the form of the question.
Grounds.
He's referring to videos, and if he is, that's fine. If he could just clarify videos or exhibits.
Exhibits. At what time did you see all the exhibits in their entirety? Was it the same day or was it different days?
Not the videos, but the photos, as you're explaining in these exhibits, prior, just in preparation of my testimony.
In preparation of your testimony? What do you mean by in preparation of?
Kind of recall my memory, anything to that nature, making sure that everything is accurate in what I'm going to testify to.
If everything you're going to testify to is truthful, why would you need to prepare for it?
Objection.
Grounds. Why would you need testimony preparation? Wouldn't it be easy to just come in and recount what you saw?
Objection. Argumentative.
Grounds. Is it fair to say that it would be fairly easy to state what you saw that evening? So why exactly did you feel the need that you had to prep yourself?
Objection. Argumentative.
Grounds. I'm going to direct your attention to Exhibit 154, which is a video. So that's clear for the record, not a still frame. It's a video.
You want to put up for him?
I want to put up for him. Can we go to 41 seconds? Is it fair to say that...
Do you want to wait until the jury has it in front of them?
Yeah.
Okay.
So in this exhibit, which is a video that's paused at 41 seconds, we can see 2 people laying on the ground. Would that be fair to say?
Yes.
Can you see any of the 2 people's faces right now as it's paused?
No.
So it would be fair to say that you can't positively say who that is from this part of the video that's paused right now.
Well, based on my experience, based on clothing descriptions, Obviously, Adair and Marisol are mother and child, and body structures, that's how I'm able to identify who they are.
What do you mean by body structure?
Well, Adair is a little bit smaller, and Marisol's a little bit larger, and that's how I have memory of who she is.
Would you agree that they're kind of like bunched up, like kind of balled up?
I would agree that Adair is, yes.
Can you see faces?
No, sir.
So it would be fair to say that you don't know for sure who that is?
I'm pretty confident that's Marisol and Adair.
Pretty confident?
I'm very confident.
So why not be very confident the first time that question was asked? Grounds. Let's go to 58 seconds and pause. Right here in front of us, we see 3 people kneel down. We see someone with a pinkish blanket covering them, and we see a lady with a black coat with a white kind of like top to it. Is that fair to say?
Yes, sir.
Can you see the face of the person laying on the ground under the pink blanket?
No, sir.
Would it be fair to say that you don't know for sure who that is?
As I described before, I'm very confident that that's Marisol that's laying on the ground.
And how can you tell that from the picture that we're looking at now?
Well, not specifically just from this picture, but like I stated before, as the video was moving, you could see clothing descriptions, body structure, who she's laying next to.
Is it fair to say that the exhibit is not moving right now? It's paused.
Yes, sir.
And it's paused with not being able to see who's under the pink blanket. Would that be fair to say?
Yes, sir.
So how can you say for sure who that is?
If I was to just view this video or this photo without any other context, you're probably correct. I probably wouldn't be able to identify any particular person, but because of the video and how it moved and how I was able to see people, I was able to confirm that'd be Marisol.
And you came to that conclusion because you've seen these videos before today, or these exhibits rather before today. Would that be fair to say?
I come to the conclusion with my memory of being there at that night.
But you did state, just so we have clarity, that you in fact saw these exhibits before today. Would that be fair to say? Grounds. Towards the, I'm guessing that would, if you're looking at it the way I'm looking at it, it'd be towards the right. We're coming back a little bit more. Right where the lady with the white coat is, you see a few people, it looks like 3, kneeled over someone that is under a blanket with, it looks red with like snowflakes or something on it. You can see like a black, I don't know if that's like a shoe, or I'm guessing that's a shoe or a boot or something to that effect. Is that fair to say that you can see that? Can you tell who that is just looking at it right now?
I know that that's Gregoria, yes.
Can you tell who it is looking at it right now? Can you see their face? Can you identify them right now? So it'd be fair to say that you're not sure who that is.
I am sure who that is.
And you come to that conclusion based on what we're looking at right now at this moment.
Objection.
Grounds.
Characterizes this witness's testimony.
Grounds. Let's go to 136. Same exhibit in pause. Is it fair to say we can see someone with laying on the ground? They have like a bluish jacket. You can only see one arm, so the sleeve. The jacket is blue. It looks like they have like something red next to, which is obviously a lady in a gray jacket, white hat, a guy in a red, looks like a hoodie, and someone else to their right, I would say, and a jacket and a cap with looks like a baseball cap. Would it be fair to say that you can see that?
Yes.
And the person that's laying on the ground, can you see their face?
No, sir.
So would it be fair to say that you don't know for sure who that is?
I'm sure I know who that is.
Based on what we're looking at now, you can tell who that is?
Based on my recollection of the incident that night, I know who that is.
Based on what we're looking at right now on the screen, can you tell who that is? You
Yes,
can
sir.
see their face?
I know who that is. I cannot see their face.
So it'd be fair to say from this picture, you're not sure who that is?
Objection.
Grounds. To the right of the screen, right here. Can't tell how many people is kneeled down right there, but it's obvious that they're attending to somebody. Would that be fair to say? Can you see who that is that they're attending to in any way? So it'd be fair to say that you don't know who that is that they're attending to, correct?
I know who they're attending to.
And you can tell that by what we're looking at right now? Grounds.
Characterizes the testimony.
Grounds.
Witness testified as this video was going through who he believed each person was.
Who he believed. Can you tell from what we're looking at right now? Can you tell who that is that they're attending to?
You cannot see that is Jason Petchoff behind them, but that is who is laying on the ground right there.
And you can tell that by what we're looking at right now. You can see who that is.
No, based on my recollection of the incident is why I know who that is.
I'm saying referring to what we're looking at, not your recollection, what we're currently looking at right now. Can you tell who that is that's being attended to from based on what we're looking at right at this moment? Can we go to 2 minutes and 30 seconds? Can we erase that circling arrow? Right in front of us, we can see a group of people standing over someone who appears to be laying on the ground. Would that be fair to say?
Yes, sir.
It looks like they have a Scooby-Doo blanket over them. Would that be fair to say?
Yes, sir.
By what we're looking at right now at this moment, can you tell who's under the Scooby-Doo blanket?
I know who that is.
Can you tell by what we're looking at this moment? At this moment right now, can you tell who's under the Scooby-Doo blanket? Can we go to 241 and pause? Would it be fair to say that right now we're looking at what appears to be, could be a police officer, some kind of law enforcement, could be security guard or anything, but some type of law enforcement. We see someone, it looks like a woman who you can't see the top of her head, but you can see like her chin and her bottom lip has a black jacket. And right in between those, the law enforcement and the woman, you can see that someone's laying on the ground and you see 3 people attending to them. Would that be fair to say?
Yes, sir.
Can you tell by what we're looking at right now? Can you say exactly who that is?
100% confident because I'm in that photo.
And is that you standing over the front of him?
I'm standing over my son.
Or not standing, I'm sorry, I didn't mean to cut you off. Kneeling in over the top of who's on the ground.
Yes, my son is crying because he just got struck by a vehicle and I'm trying to console him.
That wasn't the question. That's you kneeling over with the hat, and it looks like a grayish, I don't know if that would be a hoodie, but looks like it's some bluish black to the sleeve. Would that be you?
I'm wearing a gray sweatshirt. My son is wearing the blue jacket.
I could be mixed up. I apologize for that. So it would be safe to say, by what you just said, you were 100%, you were adamant, 100% that you knew who that was. Mm-hmm. Would that be fair to say?
Yes, sir.
But you didn't have that same enthusiasm for everybody else that we were just looking at. Would that be fair to say?
Objection mischaracterizes this witness's testimony.
Grounds.
Sustained.
And out of all the exhibits that you were shown during the initial questioning, you're not sure who took any of those videos?
No, sir.
There was quite a few exhibits that were shown. Would that be fair to say? And do you recall exactly the estimate of how far the vehicle was from you when you first saw it? And how did you come to that estimation of distance? So you felt that estimate was pretty accurate?
I don't know.
Or did you know for sure? You stated that your 9-year-old was in your right hand and your 3-year-old was in your left hand. Would that be fair to say? You stated at some point that your 9-year-old was ripped, or you didn't know if your 9-year-old was ripped out of your hand. Can you explain what do you mean by ripped?
I didn't know if it was the force of the vehicle taking him away from me that forced our hands to be separated.
And was that 9-year-old injured?
Was thrown in the air and he was knocked unconscious.
What happened with your 3-year-old that was in your left hand?
I threw him with my left hand towards the curb. He did not get struck.
When you say threw him, what do you mean by that?
I was holding on to it. I'm sorry.
A quick toss, or was it like a harsh push, or define thrown?
I grabbed him off the air and threw him as far as I possibly could because I knew that he was going to get hit by a car.
Do you recall if he was hurt in the throat?
Objection.
Grounds.
Relevance.
Other than that, was he injured in any way? You made a reference to the speed. How did you come to that estimation of speed? Do you have any expertise in speed analysis? So it would be fair to say you don't know for sure. And I assume that you were interviewed by other officers at some point. Would that be fair to say? Do you recall if it was that night or if it was in the following days? And you already stated that your 9-year-old son did get struck. Did you actually see that? Even though you had him in your right arm, or right hand rather. Did you see where the vehicle went after it passed you? Did you see anyone else get struck once it passed you? In a summary of your report, do you recall stating to the officer that you were interviewed by that you saw a second unconscious person laying on the ground that you further described as a Hispanic female? would it be fair to say that in your testimony here today you gave names? That'd be fair to say?
Yes, sir.
Why not in the summary of your report did you give names and just say a Hispanic female? I was referring to him already testifying that he had knowledge of everybody that was in his group.
Rephrase your question, please.
At the time of your summary, did you know the identity of the Hispanic female that you referenced?
An objection to the form of the question. It's not his summary
Ground.
per se.
Sustained as to the form of the question.
So should I say in the summary that you gave, do you recall that comment?
Objection mischaracterizes the summary.
Grounds. In the summary that was given by the officer that you gave the report to, do you recall that statement?
I believe what Mr. Brooks is looking at is a different officer's report that summarizes the statement that that officer received from Detective Hallmark. That's what it is. I would ask Mr. Brooks to maybe ask his next question with keeping that in mind.
Objection to being called that. I don't identify by that name nor consent to being called that name. And I
Next
made
question,
reference,
sir.
You made reference to your son being attended to by two men. Would that be fair to say?
Yes, sir.
At the time of the incident, did you know who those two men were?
No, sir.
And when did you learn of the identity of those two men? Do you know if they, or do you recall them giving you any additional information that you didn't have that night?
Yes.
Do you recall if they were active participants in the parade or just spectators? Did they give you that information at any time? To your recollection, did the spectator tell you where they were positioned at when they attended to your son? And who is Charles?
That'd be my 3-year-old.
And Benjamin?
That'd be my 7-year-old.
Do you recall what happened with Benjamin when you saw the vehicle approaching?
Yeah, he was run over by the vehicle.
Do you at any time recall making a statement in the summary that was given by another officer? Do you recall making the statement, you threw Charles and Benjamin as hard as you could towards the south curb?
Yes, sir.
If you already stated that you threw your 3-year-old, which you just said was Charles, and you also just acknowledged that you threw Benjamin.
Objection as to the characterization. He acknowledged that the summary that Mr. Brooks is reading said that he threw Benjamin.
He answered the question.
He did not.
So did you throw Benjamin as hard as you could to the south curb, or did you see Benjamin struck by the vehicle?
So when the vehicle was coming and I threw Charlie, I knew that Ben was in front of us, so it was the same motion with my left arm to get Benjamin and Charlie out of the way.
Any idea why that was not in the summary?
I don't recall.
Grounds. Besides your children, the other people that you observed injured, did you immediately receive information what those injuries were at that time?
Can you repeat just to be clear of who you're talking about?
The other people that were with your group, not your children, but the other people that were with your group. Do you recall receiving information about their injuries at that time? So it would be fair to say you knew that they were hurt, but you didn't know the severity of it.
Exactly.
Is that a yes?
Yes, sir.
And besides your children, who else was with you when you attended the parade that evening?
Me and my immediate family, so it was me, my children, and my wife.
Do you recall your wife being injured in any way during the incident? Do you recall where she was when the vehicle passed you? Was she directly next to you, to the side of you, standing right next to you, or do you remember the general area she was at that moment? And she didn't report any injuries of any kind. No further questions.
Any redirect?
Real brief. Sir, the identifications that you made in the exhibits that were shown to you on direct examination, are you 100% confident in those identifications?
Objection. Hearsay.
I just have a couple of housekeeping matters. Please be seated. Then, just Mr. Brooks, those things were provided to you.
Yeah, I set value, return for value these filings, and just very briefly so we can get out of here, I have to raise this issue.
What issue, Mr.
My
Brooks?
understanding, how can someone who's not an injured party testify on behalf of somebody who is an injured party.
Mr. Brooks,
and it still be
I'm
charged?
not addressing this. It is a frivolous argument. You have a misunderstanding of the law. We are in recess. I am leaving the bench. Thank you, everyone. We're in recess.
So that's a tacit agreement. We're not.